It may come up on Tuesday, 13th.
Pardon to mention before your lordship, item number 66. Kindly take last matter of the day, my lord, is urgent, my lord.
Let us try. We will try.
My lord, otherwise he will prejudice, my lord, the petitioner.
What is the matter about?
Matter of contract, they will cancel my contract and hand over to other vendor to
Who is for the other side?
state, my lord.
No private party.
No, my lord.
I pardon to
Kindly,
mention.
my lord.
Please inform the other side. We will see.
State.
कौन method दोनों number
I mean, pardon to mention, my lord,
66
Read 65 of 2022, my lord. My case was allowed on 17/2/2021 for grant of time-bound advancement of scale-up pay. But though I have lost a caveat, ignoring that the state has issued notice to other side and state has issued notice to me, and again I have appeared, my lord. My lord, I am deprived of my best legitimate dues, that is time-bound advancement scale-up pay since 2021, my lord. It
Can you
was
mention
listed on,
there
my
the-
lord, on May, thereafter did not come, my lord. It was listed on May before this honorable court. So I pray this may come, my lord, in it.
It will be listed. Please seek consent of the state. Please seek. You are not the applicant.
I am the respondent, I am deprived.
So you are deprived. If you want that appeal to be heard on priority basis, please seek his consent first.
I have sought their consent, it was listed, but after that did not come. I
It was
waited for
listed
a,
when?
my lord, listed on May 2024, this.
Please seek his consent again.
Take the endorsement on the memo. Throw it to him. Memo and then mention that is all that is there. So that they can get ready with that case.
ସେମିତି କିଛି ମାନେ ଡିସିସନ ଟା ରିପୋର୍ଟେଡ ଡିସିସନ ତ ସେମାନେ ଜାଣିଛନ୍ତି ଆଉ ଥରେ ସେ କହିଥିଲେ ମିଷ୍ଟର ଖୁଣ୍ଟିଆ ବି କହିଥିଲେ ଆର୍ଥର ବି ଖାଲି ଲିଷ୍ଟ ରେ ଆସି ପଡିଲାନି ଯେହେତୁ
But why are you speaking in Oriya? Is it a private conversation here?
no. As because the last time
No, it's all right. You have been asked that give them notice, there are. All right.
yes.
Seek
Malad,
their consent, Mr. Counsel. Please go to the learned counsel who appears for the appellant in this case. Seek his consent. If he declines, even then you make a mention, but please let us know that you had attempted to inform them that you are going to make a mention.
And after taking their consent, will I move before register or here, my lord? Will I?
Why is that matter so urgent? It is not urgent. There are so many cases which have not been taken up.
It's a fresh admission. We'll try to take it up.
Yes.
My lords, may I mention WPC 13149 of 2015? My lords, I had challenged proceedings initiated by Enforcement Directorate under PMLA. My lords, in the meantime, the schedule offence, that is the predicate offence, come to be quashed by this Honorable High Court, my lords, in the year 2020. Thereafter, we moved an IA bringing this on record. And in the meantime, the Honorable Supreme Court has passed judgment in Vijay Madan Lal Chaudhary that once predicate offence has been quashed, then the ED PMLA offence won't survive. My
So
lords,
what is your matter?
my lords, basis the predicate offence, an ECIR was registered. And
No, what is your case number?
my lords, is WPC 13149 of 2015, my lords.
Please send your. All
Because
right.
my colleague,
We will see. We will see. Mr.
so grateful, my lords, so grateful.
I may be pardoned to mention, my lords, I'm on VC. My lords, item number 4 from today's list. My lords, on the learned conducting counsel, my lords, he's fallen sick. And
All right. Let the matter be called. Make a mention when the matter is called.
my lords, my lords.
Lord, I have taken the consent from the state.
All right. Give us. We will see.
Another contempt also said.
One apple a day.
Still I have to follow the.
and also I have taken note of his contempt number.
Item number 1.
Please. I have made all attempt to consolidate what is the your lordship's query, and I have answered in my note. So I'm just placing the note. I've made my all attempt to copy. At least to make it, I think these are the, apart from this, I have no other submissions. Mr. Mohanty was arguing that Patna case, therefore I've given it yesterday, the last hour. So I've given the first one, that Patna case. In case of Pramod Pandey and versus State of Bihar, challenge was made to the amendment on Bihar Polytechnic Education Service 2014 through notification dated 10/4/2017. The basic qualification for the post provide bachelor degree in engineering. In the instant case, the eligibility criteria as per Rule 6 of 2012 rule, the minimum educational qualification therein has been prescribed as bachelor degree in engineering or its equivalent. In Bihar case, the pre-amendment rules provided for total weightage of 100, out of which weightage for evaluation in work knowledge and teaching skill was 30, interview weightage 20, and weightage in written test was 50. By virtue of the amendment, the weightage scheme was altered and the earlier weightage scheme was substituted with 25 marks for marks obtained in BTech in the relevant subject. 10 marks, next one. 10 marks weightage for marks obtained in MTech, 5 marks of PhD, weightage to candidate working on contract basis under Department of Science and Technology and possessing eligibility criteria at the rate 2 marks per year to the tune of maximum 10 marks. Then 30 marks in respect of percentile obtained in GATE and 20 marks of weightage for interview. This is by way of amendment. In the instance case, the petitioner also possessed the eligibility criteria, but since the merit list will be prepared on the basis of the aggregate marks secured in the valid GATE score carrying 90% of weightage and carrying 8% weightage, the petitioner, though are eligible for participating in the recruitment process, but due to the interim amendment, they will be deprived of selection on the basis of their work knowledge. Therefore, the issue involved is identical to the case of Bihar, which has already been accepted by the division bench of this honorable court in the judgment so and so. Then next is Rule 3. Rule 3 of Orissa Civil Service criteria of such selection for appointment.
Work knowledge. Is it a necessary criteria? I mean, eligibility criteria, work knowledge.
In Bihar.
No, therefore, there is distinction between the Bihar case and Odisha, this recruitment, because there the court was of the view that work knowledge is also required.
Yes.
Here, no work because fresh recruitment of fresh engineering graduates.
I'll take your lordship to that particular portion of the judgment of the Bihar. What your lordship is correct, but the ultimate ratio, what is decided, I'll come to that. I'll not place it, then I'll take this. Rule 3 of the Orissa Civil Service criteria for selection for appointment, including promotion, provide for the purpose of initial appointment mandates a commission to prepare a list through competitive examination. Rule 5 of the said rule provides for overriding effect of 2003 rules, wherein it has been stated that the provision of 2003 rule will have overriding effect, notwithstanding anything to the contrary contained in any other recruitment rule for the time being in force. The effect of such overriding clause have been not amended any further will also prevail over the provisions contained in 2023 amendment rules. Then, so Lordship asked me the first day, so far the definition of state civil service is concerned, the same has been clarified by the GA department in the letter dated 8/9/2008. This is 88. Madam, I'm sorry, this is not 98. This is 88. I'm extremely sorry. Wherein it has been held that a post belonging to any classification which included a cadre rule framed by state under Article 309 of the Constitution of India, it comes within the meaning of state civil services, and the post having no cadre rule as civil post. You also look to that circular which was issued by the government, that is at annexure enclosure 2 at page 10. At page 10. And this has, so far as I made all attempt to find out whether it has been superseded by any other circular, but I failed. I could not get it. Enclosure 2 at page 10. You also see that circular. Bottom. This bottom in the bottom. To all department of the government. This is dated 8 September 1988. Subject amendment to Orissa Civil Service 62. In his DO letter number so-and-so dated, the additional chief secretary has impressed upon the secretaries the need of revision of CTB appended to Orissa Civil Service CCA Rule 1962. The undersigned is directed to say that in course of discussion with departmental officers, it is found that distinction between the state civil services and civil posts are not well understood. In view of this, it is clarified that a post belonging to any classification which included in the cadre rule framed by the governor under Article 309 of the Constitution of India comes within the meaning of the state civil services, and the post for which no cadre rule has been framed will be known as state civil post. All departments are requested to prepare the revised list accordingly and furnish the same to the department. This inclusion the schedule to be published under Rule 7 of OCS rules. Departments which have already submitted the information earlier are also requested to give relook to the matter and prepare the information according to guidelines given above. While sending the information, copies of the concerned cadre rule may also be sent. Then you also kindly come to page 3. Page 3, para 4. Even though accepting though not admitting that GATE is a competitive examination as per 2003 rules and Article 321, but fact remains such examination is not conducted by OPSC or any constitutional or statutory body. More so, in absence of any rule to commission to any other body other than OPSC, the GATE examination cannot be construed to be a competitive examination. Then para 5. It is submitted by the Council for the OPSC that the advertisement was published in the academic year 2023 in view of the impugned amendment rule because certain candidates who applied pursuant to 2023 advertisement will become overage. But fact remains, in the order dated 24/11/2023, passed in SLP by the Supreme Court, it was directed by the Honorable Apex Court not to deprive consideration of such candidates who have applied to the earlier advertisement qualified on being overaged. So therefore, such statement is clearly contrary to the direction of the Honorable Apex Court. Then 6. As per Rule 7.2 of the 2012 rules, it is the bounden duty of the Commission to invite application from eligible candidate upon receipt of the requisition from the government. In the instant case, due to the impugned amendment, though candidates are eligible, but no application have been invited by the OPSC from the candidate eligible in terms of Rule 6 of 2012 rule. This is a fact. Para 7. It was submitted by the Council for the opposite party that adequate number of candidates having valid GATE score are available in the open market through post of Assistant Executive Engineer as per the impugned amendment. But the same is contrary to the admitted fact that when a total 580 posts of Assistant Executive Engineer are advertised, as per Rule 7.4, the Commission is to 7.4 requires also this. The Commission is to shortlist candidate for interview 2 times of the vacancies advertised. In the present case, as can be seen from the notice dated 9/7/2024, a total 794 candidates have been shortlisted for document verification and interview, which is less times of the vacancies advertised. Therefore, it is evident that adequate number of candidates having valid GATE score are not available in the open market. Copy of such notice I have enclosed also 9/7/2024. It is humbly submitted that in a preceding year of recruitment, that is 2019-2020, a total 15,367 candidates have applied for the post of Assistant Executive Engineer in response to such advertisement. Whereas in the present case, the candidates who have applied pursuant to the advertisement dated 28/12/2023 are comparatively much less those pursuant to the earlier advertisement at the RTI information I have enclosed. Then para 9. Prior to the amendment, information was sought for from the office of the OP number 1 regarding the method of recruitment for Assistant Executive Engineer, wherein it was stated by the opposite party number 1 that the same has not yet been decided. That information is in August 2023. Then para 10. The difference between GATE examination and written examination is distinguished hereunder in the tabular form. Your Lordship wanted also to know what is the difference between the GATE examination and I have made distinction. Sorry.
Please.
Sorry. So far the GATE examination is concerned, also come to page 6, held by Consortium 6 Board IIT and IIS Bangalore. And so far the examination conducted by the OPA Constitution of India, the examination is to held by the Commission. Similarly, two. But this is another point. The fee prescribed for gate examination is 1,800, which is contrary to the rule. There is a rule, statutory rule under Article 309. Issuance of payment of application and examination fee for recruitment to different posts and services in the state government rule 2022. The rule I have enclosed, that rule provides that you can't accept any examination fees. That is the rule. That is statutory rule. So far as no fees for participating in the recruitment examination. So far the apart from gate, the other examination conducted by the OPSC, no fees. Then three, law of reservation is different since OPC and EWS category are also included, which are not recognized in the state of Orissa. OBC or EWS is not recognized by the state of Orissa. But so far state of Orissa is concerned, the examination, reservation as applicable in the state of Orissa is followed in the matter of recruitment.
But OBC category is recognized by GATT.
By GATT. So thereby persons so far the reservations applicable to state of Orissa, that is excluded, that is not there. EWS is not there also.
No, just curiosity. How is it applied OBC and EWS? Because they have to give the examinations. So they have separate papers.
So they have to give the examination. So a category, there is some OBCs. The method of determining cut-off and qualifying marks vary year to year. So far, Honorable Chief Justice is asking that question. Every year they change the method, so far as gate examination is concerned. But the cut-off marks and qualifying mark is fixed category-wise, depending upon the marks secured by the candidate in respective category. So far, the examination conducted by the OPSC. The last submission at para 11. As per Rule 3 of the Orissa Discontinuance of Payment of Application and Examination Fee for Recruitment to Different Posts and Services in the State Government Rules 2022, it has been clearly provided that notwithstanding anything contained in any other recruitment rule, that is a non-obstructive clause, or instruction regulating the method of recruitment in different posts and services of the state government, no application fees is to be collected from any applicant for appearing in the recruitment test or examination conducted by any recruitment agency. But in the instant case, though OPSC is not directly collecting the examination fees, but the candidate intending to participate in the required recruitment process have to pay the prescribed fees for appearing in gate examination, which indirectly amounts to collection of examination fees. Hence, the impugned amendment clearly frustrated the intent and purpose of 2022 rules. Just kindly look. I'm giving the amended rule of Patna along with this enclosure. That is, I'll show it while placing that judgment. That is at page 8 of this compilation. Now, so kindly look to the judgment. I'll place only those relevant portions which my respective submission is that can be at least be constituted to be a ratio. You'll also kindly come to page 206 of my brief. That is WPC number 8166 of 2024. So straight we come to the Patna judgment at page 206. What are the subject matter of challenge? And what was the question raised in that Patna judgment and what is the answer? Let's get it at page 206. Yes. First paragraph, what was in each of the two writ applications, the prayer is common and the challenge is made to the amendment in the Bihar Polytechnic Education Service 2014, herein after referred to as rules, notified through notification dated 10/4/2017, whereby table 2 of appendix 1 has been substituted to waive of the requirement of a written test for the purpose of evaluation of work knowledge and teaching skill, and which has given a way to evaluation on the basis of the percentile obtained by a candidate in GATE graduate aptitude test in engineering examination, hereinafter referred to as GATE. Consequently, the petitioner have also questioned the advertisement dated 7/3/2019 and 8/3/2019, copy of which are placed on record. For the sake of ready, next paragraph, for the sake of ready reference and to demonstrate the commonness in the relief rate that we reproduce the prayer so made in paragraph 1. Paragraph 1. Just I am reading this, then I'll take your lordship to the relevant portion. For setting aside the amendment in Bihar Polytechnic Education Rules 2014, though the notification of the Department of Science and Technology, Government of Bihar contain in memo number so and so, through which the table number and table 2 of Appendix 1 of Bihar Polytechnic Education Service 2014 has been substituted by the newly amended table 1 and table 2 of Appendix 1. The eligibility and educational qualification has been changed by adding 30 percentile obtained in graduate aptitude test score, GATE score, contrary to the qualification for direct appointment to the post of lecturer in Polytechnic institution determined by the All India Council of Technical Education. So therefore, kindly come to page 213. What is the argument which was advanced? Page 213. Learning Council, page 213. Learning Council has next taken us through Appendix referred to in Rule 5 to submit that by Table 1 of the Appendix 1, prescribed qualification and experience to be possessed by an applicant against such appointment. Table 2 under Appendix 1 provide for a weightage scheme. Concentrating on the issue canvassed in the writ application, which is in respect of appointment of lecturer and assistant professor in the Government Polytechnic, Government Women Polytechnic from the engineering batch, he submits that the basic qualification for such appointment as per Table 1 is a degree in engineering technology in the relevant branch. Adverting to the weightage scheme at Table 2, he submits that the distribution of 100 marks can be found, and while 30 marks is earmarked on academic, 50 marks on evaluation of work knowledge, teaching, skill on the basis of the written test, the remaining 20 marks is earmarked for the interview. It is submitted that while the pre-amended scheme of evaluation, though resting on the syllabus prescribed for GATE, laid no mandatory condition for passing such examination to obtain such weightage. There is a clear deviation in the amendment introduced to Table 2 of Appendix 1 by the interim notification bearing number so and so dated 10/4/2017, whereby the evaluation on the basis of the written test has given a way to evaluation of the marks obtained in the GATE examination, subject to award of maximum 30 marks on the work knowledge and teaching skill. Then, sir, kindly come to page 221, the finding. Page 221. Running page 221, internal page 17 of that judgment. In the nature of the dispute,
Yes.
in the nature of the dispute, thus, which transpires from the arguments advanced by Mr. Singh, Learned Counsel appearing on behalf of the as by the Advocate General and Advocate General, we do not find it necessary to delve into the issue of separation of power because of our opinion, such conflict does not arise in the present case. Let's keep over. It is now to be seen whether the amendment to Table 2 of Appendix 1 to the rules framed by the State of Bihar had memo dated 10/4/2017 at Annexure 8, in so far as evaluation on work knowledge and teaching skill is concerned, would sustain the test of Article 14 and 16 of the Constitution of India and of the or whether it strikes at the very root of the equality, equal opportunity and equal treatment to all in the matter of public employment. Next page, page 222. For the purpose, we are persuaded to take note of some of the relevant portion of the Service Rule 2014, which was framed for appointment to the post of teacher in Government Polytechnics, Government Women Polytechnics institution. While Rule 3 provides for the cadre structure and empowers the state government to frame service condition, the regulatory provision for direct appointment is present in Rule 5 and which is provided in Appendix 1 accompanying the said rule. Since the present case relates to the appointment of lecturer and assistant professor in the Government Polytechnic and Government Women Polytechnic from the field of engineering, we would make reference to the prescribed qualification and experience for such direct appointment as present in Table 1 of Appendix 1, which runs under Bachelor degree engineering public technology, bachelor's degree in engineering, engineering technology in the relevant branch with first class or equivalent. If the candidate has a master degree in engineering of technology, first class or equivalent is required at bachelor's or master level. The weightage scheme originally existed in table 2 of appendix 1 insofar as the field of engineering of the technology is concerned, provided as follows. Total weightage, let's see, cadre post, academic records and research work, right hand column, evaluation of work knowledge and teaching skill through interview weightage is 20. Next page. Engineering technology weightage 30, that has been divided A 15% of the mark of this is the amendment. This is subsequently amendment. 15% of percentage of marks obtained in BTech in relevant branch subject. B 10% percentage mark obtained in MTech in relevant branch. Then PhD 5%. Then written test. Right hand column. Weightage 50. B. Let's see the column. B. Yes. For engineering / technology stream, the syllabus of graduate aptitude test engineering GATE. That is there. And a plain look to this is the finding. A plain look to the qualification prescribed for appointment in table 1 would confirm that the basic qualification for such appointment is a bachelor degree in engineering technology. In so far as the weightage scheme is concerned, as against total weightage of 100 marks, 30 marks academic record research work, 50 marks is reserved for evaluation on work knowledge, public teaching, skills to be done through written test, and 20 marks is reserved for interview. Now, whereas weightage of 30 marks on academic records allow 15% of the mark obtained BTech, 10% marks obtained in MTech, and 5% mark in PhD, the evaluation of work knowledge and teaching skill was to be done through a written test for which the syllabus of GATE was prescribed. Then let us kindly come to the next page, page 224. This on top, this weightage scheme at table 2 has been interfered with by the impugned amendment at annexure 8, whereby now 50 marks is reserved for academic records, research work, 30 marks is reserved for evaluation on work knowledge and teaching skill on the basis of the mark in GATE, obtained in GATE, and 20 marks for interview. There is absolutely no issue on rearrangement of weightage marks amongst the different categories. The problem which arises by virtue of this amendment is in the process of amending the scheme of evaluation on work knowledge and teaching skill, the state has done away with the scheme of written test, and in so far as the candidate seeking appointment in engineering and technology branch is concerned, they are now to be assessed on the basis of the percentile obtained by them in the GATE examination, subject to a maximum of 30 marks. It is the contention of the petitioner that qualifying a GATE is a mandatory requirement for seeking admission in master and doctoral program in engineering, technology, architecture, and since the petitioner already having postgraduate qualification, they are not required to appear at such examination. According to Mr. Singh, while the petitioner are not required to pass because they are already postgraduate, and this situation deprives them to the valuable 30 marks for being evaluated on the work, knowledge, and teaching skill. We do agree with the issues canvassed and are completely at loss to appreciate this change in the procedure of evaluation of candidates on their work knowledge, teaching skill, because while the weightage scheme as it was originally framed allowed equal opportunity to all candidates for being tested on their work knowledge, teaching skill through written test to be held on the pattern of GATE, the state by waiving of such requirement deprive the candidate who are not even required to pass GATE examination for being evaluated on their work knowledge and teaching skill, even if they do possess such experience. Even if the state under Article 309 has a right to frame rules in the matter of public employment, every such rule has to withstand the test of arbitrariness and rationality, besides being transparent on the procedure. But the amendment substituting table 2 of appendix 1 through memo number so-and-so 10/4/2017, whereby it is decided to waive of the transparent evaluation of candidate on their work knowledge, teaching skill by way of written test, and to simply marks obtained on the basis in the GATE examination, not only hit transparency, but also discriminates against such candidates who are already postgraduate and are not required to serve GATEs. Then also kindly come to page 228, the ultimate conclusion. Referring to the argument advanced by the Advocate General, page 228, we'll also come to the second paragraph. The amendment in our opinion, insofar as deprive the candidate, like the petitioners, to a consideration for evaluation for their work knowledge and teaching skills simply because they have not possessed is arbitrary and discriminatory besides lack in object. In such view of the matter, and for the discussion above, the amendment to Table 2 of Appendix 1 by memo number so-and-so dated 10/4/2017, insofar as it ousts the candidates who have not passed the GATE examination for being evaluated on their work knowledge, teaching skill, is held discriminatory in application. So this is my argument. Now, Mr. Pali, to add something.
No, but where is the rule which you have provided?
Yes.
That is not
That-
complete.
This is the only I have given the amendment. I could not able to get in. That is the problem. My one friend tried his best yesterday to find out from the net, but the original rule could not able to get it. Only the amendment rule I got it, and that I have annexed as page 8. If you also permit me, I will try to again find out from somewhere from the judges library it can be available. So I will try to get it because that is I was thinking that I should have placed that also, the original one, because whatever is quoted in the judgment, that is not, the entirety has not been quoted. So they partly quoted.
No,
So
we are referring to which rule? 14 rules.
we have I have enclosed that 2014 amended rules, but the original rule of Patna,
No, not Patna, your Odisha.
2012 rule,
Yeah, where is that?
that is there.
Yes,
I've
sir.
given.
That is not complete.
No, your rule I have given.
Valid document. Yes.
Earlier I had given to your
Yesterday
assistant.
the
Yes, it is there with us. Where is the syllabus?
Syllabus. I think there is no syllabus in the rule.
There is no syllabus.
No syllabus in the rule.
There's another thin one.
Sure.
I can't say so confidently sure, but so far as my knowledge goes, there is no syllabus.
There is a hypothetical question
Yes, sir.
that suppose they had decided by that the score in Union Public Service Commission examination for Indian engineering service shall be taken into account for the preparation of merit list. So doing away with the written examination instead of GATE, had there been a provision under the rules that your score in the examination held by the Union Public Service Commission for Indian engineering service shall be taken into consideration for preparation of merit list. It's a hypothetical.
Yes. So far as that part is concerned, my respectful submission is they can. But subject to so far the Union Public Service Commission's Indian engineering service is concerned, provided that that is provided in the syllabus, provided they have the opportunity to go, that is depending upon the various factors.
So this can be a method of selection for all the state, even civil services also, administrative services also. They may say that we shall not hold any written examination and we shall decide, prepare merit list.
So far
on
the
basis
written
of-
examination is concerned, that your lordship have already, there is a interaction concern, Article 321, the role of the commission cannot be ignored in such manners. That examination has to be conducted by the commission. It
That
cannot be
exam-
delegated to any other body.
That examination is written examination or not, you have not been able to convince
Yes.
the court fully.
So the competitive
Because-
examination as referred to in 2003 rule, that must be read with Article 321, that examination. And so far the written, and one line you also see the counter, what is the counter of the state that so far written examination is concerned. You also look to that, one line. What they have said. They have said like this at page 11, paragraph 11, last line. The impugned amendment has replaced the written test with another written test named That is what they say.
Where is that?
That is at page 11 of the counter, internal page 11 of the counter, paragraph 11, last line.
Counter in your case.
Yes, Satyavrat Sahu case. One part they said, moreover, gate score is a screening test and is not educational.
Paragraph 11 of
Of
8166.
counter affidavit filed.
8166.
8166. Filed by OP number 1, respond number 1. Manjulata Swain, at present a special secretary to government. Also look to that last 4 lines. Moreover, gate score is a screening, not an educational qualification. The impugned amendment has replaced the written test with another written test, namely gate.
So this is very crucial. This is most crucial. Rao.
Most crucial, most crucial. That's right. Yes, Mr. Bali. So, only one thing, can I just 1 minute? You also look to that 2022 rules. That is a statutory rule. That I've given in, along with my note today, additional note. Just it is my duty to bring to yourselves notice. Last page 18. Recruitment agency has been defined. This is a rule also see in exercise the power conferred by the provision on Article 309 of the Constitution. Then the Governor of Orissa is pleased to make the following rule to regulate the procedure of recruitment to different posts and services in the state government.
Where are you reading?
I'm reading page 18.
Yes.
In exercise the power.
Yes.
In exercise the power conferred by the proviso to Article 309 of the Constitution of India, the Governor of Orissa is pleased to make the following rules to regulate the procedure of recruitment to different posts and services in the state government, namely, so and so, so. 2. Recruitment agency means, recruiting agency means Orissa Public Service Commission, so and so, so and so. Yeah. Then kindly come to 3. Notwithstanding anything contained in any recruitment rule or regulation or orders or instruction, but the time being in force, regulating the method of recruitment to different posts and services. No application or examination fee shall be collected from any applicant for applying or appearing in the recruitment test or examination conducted by any recruiting agency for appointing to the post and services under the state government. Now, so far gate is concerned, they have 1,800, they have collected the fees of. So this is also contrary to this. Yes, that's it here. Come here.
I just like to add minutes a few things to my learned senior submissions minutes. And in a way, minutes supplement that. Lordship may take up my counter, that is Mirasri Suman, WPC 42059 of 2023. My counter, page minutes 18, annexure B1. This is the policy decision that was taken. They are taking the protection that it's a policy. And this was the policy decision that was taken. After your lordships, this honorable court struck down the first Mallard's amendment. Thereafter, Mallard's, the present amendment, this is the background of the present amendment, background in which the present amendment was felt necessitated that the present amendment should be passed. I'll take your lordships to paragraph 2 straight away, Mallards. If paragraph 1, SLP may not be filed against the order dated 1/5/2023 of the Honorable High Court of Orissa passed in so and so, filed by Pradyumna Kumar Patra and others. 2, loss of time. 2, fresh proposal be sent to OPSC seeking their concurrence on amendment cadre rule That is the Odisha Engineering Service method of recruitment and conditions of service rules. For recruitment to the AEEE Civil and AEEE Mechanical by adopting valid gate score of preceding 2 years instead of 3 years proposed earlier, in lieu of written test and viva, so as to ensure, well, this is important, utmost transparency in the process of selection, 1. 2, entry of talented engineering cadre from a wider pool of resources, and timely completion of the recruitment process. These are the 3 conditions. Now, my lords, necessarily the education system as it is structured today, my lords, far more number of BTech candidates who appear, my lords, or existing in the market who are BTechs. That's it's in a pyramid structure, my lords. So this structure is being narrowed down. By going for gates, you are narrowing the field. The catchment area is being narrowed, my lords, for eligible candidates to appear. The original eligibility criteria as it existed and still exists under Rule 6, my lords, keeping Rule 7 apart, where they have tried to, my lords, virtually it's an amendment of Rule 6 under the guise of, my lords, prescribing fresh method of selection. The rule which provides fresh method of, under guise of fresh method of selection.
The gist of your submission is,
my lord,
that by providing gate as compulsory
my
of recruitment narrows down.
instead of a wider pool.
Always.
I will give the statistical, my lords, the
Statistical, we cannot look into that.
the data.
Data we cannot, because something which is not there on affidavit, we cannot take note of that. You have made your submission, we will, and
Well,
you are not required to give any data.
Well,
So apparent that that only such candidates, if this rule
Well,
is applied, only such candidates who have valid gate score can be considered. The other wide this thing they have been ignored.
that is in sync with the constitutional mandate, matters 14 and 16, equality of opportunity.
All-
And also, I'll just read from that statistics, my lords, so that your lordship will get, because prior to, my lords, these are statistics which are prior to the amendment.
Mr. Palit,
Ma'am.
should we take into account anything, any fact which you are stating during the
This is
course
it.
of your submission, which they don't have the opportunity to address?
This is a part of the OPSC manual, OPSC annual report. This statistics is part of the OPSC annual report, my lords. This, man,
Which is not there on record.
I'll restrain from that, my lords. There's one more aspect, my lords. There was one more aspect which was, my lord, in that chart, gate and. I'm passing on a chart as your lordship, it fell from your lordships yesterday. The chart where the comparison chart, my lords, between gate and OPSC, my lords. All the points have been covered by my learned senior, my lord. There's one more point. The OPSC exam, my lords, in the syllabus of the OPSC exam, we have building, my lords, paper 1 in the page, lordship may come to page 2, right hand side column. This is the OPSC syllabus of the OPSC exam, paper 1. Building material, the fifth, my lords, column, the item. Building material, building construction and estimation. My lords, what?
This is what we wanted to know. Where is the syllabus?
My lords, syllabus of the OPSC exam. We will file it. OPSC exam, the syllabus.
So then how can you compare if you don't have?
I'll
In fact,
Yes,
Dayanand
sir.
Mahapatra appearing for one of the interveners, my lord, of argument, where the syllabus has been provided, both for GATE as well as OPSC, my lord.
No, who has provided syllabus for OPSC?
No, for GATE it's there, my lord.
No,
GATE
Okay.
OPSC.
Whether it's is there any syllabus for OPSC? And we must tell you that there cannot be any rule, recruitment rule, which contemplates examination without syllabus.
Minutes. OPSC
So there
syllabus.
must be some syllabus somewhere.
And this has been checked up by the the instructions of the client. When OPSC syllabus has been checked up, we can always furnish it by way of a
We don't
written.
know, we will have to find out.
Well,
Do we have
will
any-
always.
No, my lord. I'll,
Well,
so
this-
far as 2012 rule is concerned and amended 2014, in that rule there is no syllabus. But sometimes, Your Lordship, in that they have annexed the document of that advertisement of Panchayat Raj Engineering Service. So their OPSC prescribes its syllabus. But
That can be done.
Your Lordship has heard yesterday that one senior was arguing that there is a syllabus that has not been changed. So in fact, there is no syllabus in 2012 rule.
So the syllabus.
Only OPSC has provided.
OPSC has to prepare the syllabus when the examination starts. That prescribes in that
If
advertisement.
there is no examination, then why syllabus?
Yes, no. So for 2000, my lord asking whether in 2012 there was any syllabus, because yesterday there was an argument that syllabus is there. So without changing that syllabus, they have gone for GATE.
This comparison has been made, as my friends are under instructions. The 2019, when there was an exam conducted by the OPSC, there was a syllabus. Rightly, as your lordship said, my lord, there cannot be an exam without. So this comparison is being made from the syllabus as it existed in 2019 prior to the my lord's amendment. Because thereafter, my lords, it has been an amendment has been challenged.
No, we want to know whether the syllabus was part of the rules.
Syllabus was
syllabus
not
can be-
part of the rules.
Forget.
Syllabus was not part
All
of the
right.
rules. So it was, my lords, it was by the OPSC as
By the OPSC.
basis on which the
All right.
examination was
All right.
conducted. But that was a recruitment exam, my lords. The thrust of my submission is this, my lords, that the GATE exam is purely designed by the virtue of its syllabus for students, my lords, who are interested for going to further studies. That is where, my lords, for those kind of jobs or where, my lords, MTech is a necessary criterion, PhD is a necessary
That
criterion.
argument has been made, Mr. Pali.
My lords,
That argument has already been made, that GATE is taken only
Man.
for PG entrance.
my lord, that part of the argument has been made. I concede, my lords. The other part which I am emphasizing here is this, my lords, that there are 2-3 essential requirements which are, my lords, which could only be the requirement for a recruitment exam for the post of assistant executive engineer is this, my lords: building materials, building construction and estimation. An engineer is supposed to, my lords, have a estimation, to be an expert in, also have a very good knowledge and to be tested for his knowledge of estimation, my lords. My lords, when contract works are prepared, tenders are floated, my lords, there is a estimation plays a key role. And my lords, assistant
That the candidate must have studied in while pursuing his BE course.
they are not being
No question
tested
of
in GATE.
testing. There is no question of testing. The commission decides that they will hold an objective type test,
My lords,
and in the objective type test,
my lords,
that they will be putting questions in history,
my lords,
geography,
my lords.
some from mechanical engineering also,
Well-
some from. So you cannot say that the OPSC is bound to test his understanding in building material and those things. We are not here to decide what should be tested by the OPSC.
No, I'm not on that. I was suggesting, my lords, that there should have a rational nexus. We are not testing for an MTech examination. For an MTech examination, that pattern of a test is all right. But when when the test is being conducted, for, my lords, a selection to the process of an executive engineer is a service recruitment test, my lords. There he would be required to be tested on things which he would be encountering in his everyday, my lord, discharge of his duties.
It's very
official.
difficult for us to.
That or what he has
That-
studied. What he has that
That-
he'll be
that
tested
of-
on that. And for admission to MTech also, he'll be tested on that only.
MTech, that is not there. Estimation and building material is not there.
Estimation and building material.
No.
Estimation and building material, he must have studied.
He has studied in his BTech, and that is the standard on which, my lords, the
So according to you,
my lords,
each and every subject which he had studied in the
need not-
in the
need not be-
BTech.
need not be tested.
Or-
Only the relevant, which, my
All
lords,
right.
That is up to them.
All right. If
my lord,
an examination is held
my lord,
by the OPSC,
my lord.
in which no question from this part is put, then the examination is bad according to you. Because he was required to be tested.
OPSC's 19 syllabus conduct. My lord, this happened, my lord.
He cannot enter into such.
My lord, I withdraw from that submission, my lords.
Yes.
Huh?
Anything else?
My lord, and then secondly, my lords, the other aspect is that the gate, my lords, like it fell from your lordship yesterday, I was informed, my lord, that the gate has not been. My lords, gate has also not been, my lords, properly defined anywhere. It has no statutory force. On one hand, my lord, that's a exam conducted without any, my lord, source of law, authority of law, my lords. But on the other hand, the exam conducted by the UPSC has, my lord, the force of law, requisite force of law, my lords. And moreover, my lords, there is one rule. I would like to draw your lordship's attention to one rule of my lords, by the GA department 2021 rule. This has also, my lords, this is an application, my lords, amendment rule like that of 2003, my lords. In exercise of powers conferred by the proviso to Article 309 of the Constitution, the Governor of Orissa is pleased to make the following rules to regulate the procedure of recruitment to different posts and services of the state cadre and the district cadre of the government of Orissa. Namely, these rules may be called the Orissa Civil Service Method of Conducting Physical Standard Measurement and Physical Efficiency Test and Discontinuance of Career Assessment Rules 2001. Now, my lords, this rule says that notwithstanding 4 and 5, next page, my lords, notwithstanding anything contained in any recruitment rules regulating the method of recruitment in civil services and or civil posts in respect of different posts and services in the state cadre and district cadre of the state government, there shall not be any career assessment at the time of initial recruitment to fill up the different posts and services. Then the provisions of these rules shall have overriding effect on all the recruitment rules or executive instructions or orders issued by the administrative departments governing the method of recruitment procedure, my lords. Now, this, my lords, has been in my most humble and respectful submission, my lord. This is directly saves the 2003 rules. The Orissa Civil Services Criteria of Selection for Appointment, including Promotion Rules 2003, have been directly saved by this, my lord. Rule 3. Rule 3 of that rule, my lord, the Commission of Orissa, Commission stroke Orissa Staff Selection Commission, my lords, Orissa Subordinate Staff Selection Commission, Selection Committee, or the appointing authority as in case where such bodies do not exist or do not exist, they exercise their jurisdiction, shall for the purpose of initial appointment to any service post prepare a list through competitive exam containing the names of successful candidates
equal to the number of vacancies as anticipated pertaining to the year, to that year. The definition of competitive exam, my lords, has not been given or anywhere in the rules, but what the closest that could come was from the, my lords, definition provided in the Black's Law Dictionary, my lords. I've just passed on to your lordship. Competitive civil service examination. This is the definition contained in the Black's Law Dictionary, my lords. Examination which conforms to measures or standards which are sufficiently objective to be capable of being challenged and reviewed by other examiners of equal ability and experience. Such exam may be open, in which case all may take it, or it may be promotional, in which case only those in service may compete against others in service. So, my lord, there's the implied interpretation of this, my lord, definition that at the initial stage, initial recruitment stage, my lords, normally there would be a mandate that it will be an open exam, written exam. No, I am not, my lords. Written. Written is, I am adding the written from, my lords, this. Compilation I filed yesterday, my lords. There's a, my lords, that the only inference that can lead to is that it has to be written. My lords, duties of the Public Service Commission to conduct an examination, my lords. Normally, viva was, my lords, your lordship, I'll just take your lordship again to that list of documents that I had filed, my lords. My lords. My lords. My lords. My lords.
Whether and if the appointment is direct.
My lords.
Or by way of they are required to hold
They can hold an interview.
They can.
They can. But it's not obligatory. Not obligatory.
Again, they introduce some competition.
Some by way of an
competition for evaluating relative merit.
Months.
Relative merit is what? Evaluation of relative merit is what? That is competitive exam.
Months.
Okay.
Assessment of the month.
Examination means an exercise. Examination.
Months. Months.
Right.
Months.
This can be by way of
Months.
examination or by way of
Months.
review or
Months.
that is the examination.
Just building, just drawing sustenance from this observation of your lordship, my lord. My submission is that the entire process should be conducted by the OPSC itself, because that is the constitutional mandate. What your lordship, my lord, that is also built into that it should be conducted by the OPSC. Once a recruitment is made to the OPSC is to do. Now, that perspective, my lords, giving OPSC the role of only 10% and adopting or importing the entire gate examination would be, my lords, and taking a concurrence of OPSC. OPSC's rule cannot be reduced to 10%. My lords. My lords.
That the paper must have been published in one of the Scopus index journals.
My lords. My lords.
Right.
My lords.
So that is that evaluation, whether this paper should be published in a particular journal or not. That evaluation must have been done by some other publisher, private publisher altogether.
My lords.
Whether the paper was being published or not.
My lords.
That must have been done by that paper.
My lords, correct.
The OPSC is introducing a standard that he should have a paper published in Scopus.
So that can be one of the eligibility criteria on which, my lords.
For the purpose of relative evaluation. Comparative evaluation.
My lords. So at best, my lords, it can be a career assessment kind of a
Career.
that. Second, my lords. The next submission is this, my lords. That supposing, my lords, today we have found that, my lords, as on date, my lords, it's in common knowledge that even in an exam like NEET, there has been, my lords, manipulations and
That argument we will not hear. We
my
are
lords,
not required to hear
my lords.
because something has happened somewhere. Therefore,
It may not influence your lordships while
file an affidavit that if uh, any examination is held by OPSC, no person shall challenge the sanctity of such examination.
no
Can you
that
take this stand?
that. But what I am only submitting is this, my lord. OPSC.
The answer to your submission is that an officer of recruited in IAS. See what has happened.
My lord, that
Recruitment is conducted by UPSC.
that
So that argument is
no,
that
that
here,
those
not
individual cases only prove the, my lord. That may not.
And that also related to that reservation category.
Yes,
Which is given
and
those fraud.
certificate fraud
Oh.
certificate.
that's all.
My lord, huh? There's one more, my lord, submissions I'll make that. This amendment, my lord, is, my lord, say example of excessive delegation, my lords, whereby the role of the OPSC has been reduced to only 10%, whereas it should have been responsible for conducting the entire recruitment examination in its entirety. Here, my lords, the major mark, my lords, the major 90%, the determining factor is being assessed by way of a performance in an examination held by some other authority, and the OSF.
This is not an example of excessive delegation.
My lords.
Excessive delegation of power is something else. All right.
So do you mean to say if the 10 reduce the proportion, increase it to 40%, then it will be
No,
Of 50?
no. That can't be done because Leelavati judgment is, it has to be always a healthy mix of written and the
okay, 60-40.
Leelavati judgment would say 25%, you can't, 15%.
Right,
15,
25.
you can't go beyond 15%. It is testing the person and the knowledge of the person.
All right.
Personality.
If according to you, if your submission is to be accepted,
Manner.
then had the gate was given a weightage of 40%, the matter would have been different. 40% plus.
At least there would have been at least there would have been, along with other educational qualifications, as the rules originally stood, at least all the my lords, candidates who have the minimum qualification of a BTech would have got the opportunity to appear the exam.
That means you mean to say gate has to be done away with. So it is not the proportion of person.
I make such a submission. If the gate has been chosen, then gate can be put in its own place as one of the, my lords, criterions for a career. Because what has happened here, your lordship will see in the present advertisement itself, they don't even have that minimum number of 1:2. 794 candidates have only been provisionally, my lord, shortlisted for 580 posts. So they don't even have that minimum, my lords, requisite of 11 to ratio proportion. So therefore, my lords, what I'm submitting, that the catchment area is being, my lords, grossly reduced, and my lords, that is not in terms of
Okay.
Article 14 and Article 16, that everybody should get an equal. I'm not saying that completely, my lords, persons who are below the minimum eligibility criteria should also be given a scope to, my lord. This is a recruitment exam for a government
See,
post.
your submission that it violates Article 14 and 16, it's very difficult to accept for the reason
My lord,
we has the opportunity to participate in gate score.
my lord.
The question is whether the gate score can be the basis for OPSC
My lord, abruptly,
to determine. That is different.
my lord, abruptly introducing, I'll just take.
Abruptly for the advertisement, not for the rule.
Well, the rule is also, your lordship is kindly bear with me, the rule itself, 2012 rules. 2012 rules, my lords.
Yes, we have understood.
Compilation which I have just given, my lord.
All
Just
right,
one
we will,
point.
we will see, Mr. Pandit, everything.
My lords, one point I'll just like to point out, just
What?
one, my last submission. The age limits, eligibility criteria, and the eligibility criteria for direct recruitment. In order to be eligible for direct recruitment to the post of assistant executive engineer in service, a candidate must satisfy the following conditions, namely age limit. He must have attained the age of 21 years and must not be above 32 years on the first day of January. That's the year of recruitment. So therefore, my lords, my submission is that in order to pass the test of reasonability, I should at least be given a reasonable period of in the nature of, my lords, giving out to the whole world.
So
At least 5 years, this is 11 years. The total period, my lords, during which I can be eligible to, I'll retain the eligibility to, my lords, compete for a post, for the government post is 11 years. So at least a reasonable, I may be given at least a 5-year notice. I'll get ready, I'll get prepared.
All right.
Abruptly use, my lords, introducing it suddenly in 2024, that last 2 years, you have last 2 years of gate.
All right.
That is one, my lords. And secondly, my lords, what is the guarantee that the best students, they come and appear in the gate? I might be a topper, I may not be interested to appear gate.
Don't go. Don't appear.
Only if, but it is not by, if it's.
You can run your business. You can have your shop.
There's no.
No, see, there are so many public sector undertakings which these submissions are there, but why are you making these submissions? These submissions are irrelevant. Yes.
And then the last is that gate itself, my lords, like it fell from your lordship, that if tomorrow morning the gate adds on something else, or the gate changes its name to something else, and there's no definition, there's no, my lords, categorization of the subjects, my lords.
Subject categorization is there.
Civil and
Papers.
few papers are there.
See, they can amend the rules that if this examination or any other examination as may be found suitable by the state government. The state government.
Civil services scores also.
All right. Thank you.
Grateful. I'll file a short note here.
Only few
Yes,
lines.
do it so.
But I am appealing for the intervener, and the intervener is on the same page and it's selling on the same board, selling in the same board as that of petitioner matter. So I support
We will
the
not hear it.
attention made.
We will not hear you.
Right.
You cannot support.
Right.
Intervener can only be for opposition, not for.
This intervention is in your interest.
Only your lordship asked yesterday that pattern of examination of gate and the pattern of examination of that. Lordship may see that if comparison senior counsel Mr. Palit, that in WPC number 42059 of 2023, that your lordship can find it page 25, the pattern of examination conducted by the gate. That lordship, for a moment, your lordship may see that.
No, that is not the question. Now the greatest challenge which is there before you is your own statement made in the counter affidavit
Paragraph
that
11.
you
Yes, madam,
have
that-
replaced.
No, madam, that is not properly worded. That I can say that is not properly worded.
It is your affidavit.
Yes, ma'am.
Your
That
verdict.
is my. In fact, that is not. I have seen that Yeah, I've seen that not, I can say that is not properly worded.
That is there on record since long.
But it's a fact that we are taking.
And it is a fact also.
Yes, ma'am,
It is
that
all-
I can
See,
dispute.
what you have stated is a fact also.
Yes, ma'am.
That you have replaced that. One competitive examination, one written examination by another written examination.
Yes, ma'am, that's the wrong statement. That not, I say that is not properly. I have seen
that goes to the root of the matter.
Yes, ma'am, I have seen that. But if your lordship with that rule that we are taking into account the score in the gate, that the rules. But the wordings in the paragraph 11 of that counter is not properly worded. But
see, we are trying to understand, for the purpose of this exam, for this recruitment, the purport of the expression competitive examination.
Yes, Malad.
All right.
Yes, Malad.
So that competitive examination of whatever nature is to be held by the
recruiting agency, that Public Service Commission.
Public Service Commission. So while hearing these cases, I was examining Indian Engineering Service rules also. So there is for engineering service, the syllabus is prescribed, the examination is held by the UPSC, and there is no reference to any game. Just I was, and therefore, for every recruitment, there should be syllabus.
Right.
I am failing to understand how there is no syllabus for this examination.
May I bring instruction on that one from that, or because the rule which has been annexed to the petition, there is no syllabus. If I'll bring instruction from that department, that
No,
original.
that ought to have been there in the rule somewhere, that
Yes,
the
ma'am, that-
examination shall be held. Examination shall be held for which the syllabus is prescribed.
And
in the
appendix so and so.
Since it is not there, therefore there may not be any syllabus.
My lord.
And that syllabus, the OPSC may be prescribing.
Because I have seen that one document they have annexed to that petition, that is Odisha Panchayat Raj Engineering Service, and they have annexed that rule. In that rule, there is also no syllabus. But while making advertisement, there is a syllabus is prescribed by the OPSC.
That can be done. That can be done. OPSC can decide that there should be the syllabus.
So the OPSC has a syllabus for assistant engineering exams, but I don't know for what exam it is.
Your lordship has seen that is also that your lordship can find it. That has been annexed to that. Your lordship may see page 195 of the read petition. That is WPC number 10185 of 2024.
We are closing it now.
Yes, ma'am.
Soon, because it relates to recruitment. Examinations have been held.
By Monday.
Sorry, the process
completed.
But so far as electrical engineers are concerned,
Yes.
the final list has been published. And so far as civil engineers are concerned, and already the provisional list has been published, interview has been held. My lord, only one last thing, my lord. I'm appearing for one of the interventions supporting the CADE students. My lord, we have been waiting in the pipeline since 2021. 2021 January, the amendment took place. And thereafter, my lord, immediately a batch of writ petitions were filed challenging the virus of the particular rules, my lord. And thereafter, my lord, subsequently when the advertisement was published, again, few petitioners joined hands. On 1st of May 2023, the rules were struck down mainly basically on two grounds. First is for not following the business rules. for not placing the proper materials before the cabinet. And second is the advertisement your lordship my ladyship held that candidates of 2021 were being deprived because the requirement was that the candidates would be assessed on the basis of gate score preceding 3 years from the date of the advertisement. So therefore, 2021 candidates for which 2020 must have started, 2021 candidates would be deprived. Now, here is a batch of students, gate students, my lord. We have been waiting since 2021. After the amendment took place, we have appeared for gate. But unfortunately, my lord, the rules were struck down rightly, my lord. And thereafter, the matter was carried to the Honorable Supreme Court, not by the state, but by the gate students. The Honorable Supreme Court admitted the SLP. Thereafter, notice was issued to the state. State came up and filed a counter affidavit saying that now we have changed the rules. And therefore, my lord, the Honorable Supreme Court observes since the matter has become infirm. Therefore, we've got nothing more to say except for the fact the candidate who had appeared earlier, the age thing should be taken care of. So now, on the other hand, my lord, there are a batch of students, non-gate students, but we do not know whether they have appeared in gate, not passed, and there before your lordship. So therefore, my lord,
See, you started with a sentence that the petitioners joined hands. So you are blaming whom? The petitioners.
my lord, my lord,
Join hands with the
some
With each other.
yes, my lord.
So the petitioners are, see, against you.
The non-gate students.
Then a judgment came.
Yes, my lord.
Judgment is against you.
Yes, my lord. I concede, my lord.
And then the state government thereafter
did not challenge.
did
Yes,
not challenge, they have amended. So if you have suffered from 2021, you are blaming whom? The petitioners, the court, the
No,
government.
my lord. We are blaming our faith,
And
my lord.
and again, when we strike down, we don't know what will we do, we are
Yes, sir.
not sure. Then see, it's a system.
Yes, my lord.
If you are waiting for employment under an employer whose acts are being challenged successfully, continuously, then you can blame your employer only, not the petitioners, neither the
quite-
court.
Yes, sir.
All
I'm
right.
not blaming anybody. I'm blaming my faith, my lord. That's all. my lord. And
Oh, and you have a valid gate score. You are brilliant student. You can qualify. You can engineer. You can qualify, or you can get employment in some other this thing also. You must not be waiting for this only.
no, but state government employment, everybody waits for
State
that. my
government
lord.
employment is not the Odisha only. State government, how many? There are so many states.
They also want that state government employment.
The state wants to hire the best. The state wants to hire the best.
And you are the best.
So therefore, my lord,
So you could have got some alternative.
Everybody wants to stay in the same state where they, they want to work in the same place where they stay. That is the main concern, that why they're preferring to for the AW.
Then apply for the written examination. You also argue this, that there should be written examination held by OPSC, where you can participate, and in which Odia should be a compulsory subject.
my lord, no, I never argued on that point.
This thing, paper. Knowledge of Odia should be a compulsory paper. This is your. Such arguments have direct answers. All right. But we got good assistance from all of you.
So far as the writ appeal is concerned, my lord, I will file a written note of submission. Writ appeal.
Note by Monday, Manoj.
Hmm?
Note by Monday from all of us. Note.
Do it by Monday.
Item number 2.
Supplemental is 2.
Item.
Yes.
Here I have challenged the order of the learned single judge, directing me to avail the alternative remedy, my lord.
You
Appeal,
don't want to avail.
because of the fact, my lord, alternative remedy is not the absolute bar to approach this honorable court for exercising.
That law is there.
Yes, my lord. Here is the case, my lord.
We maintain self-restraint.
Yes, my lord. Here is the case, my lord. I
Yes.
fulfill all the ingredients not to avail the alternative remedy, my lord. Because the first one is, my lord,
Where is the order?
my lord, that is at page 36, my lord. No, my lord, sorry. Page 45, my lord.
So you had challenged your suspension as well as your termination.
Termination.
The court said for termination, it is there, so
My lord,
relegated.
the what it is that it is not maintainable is also wrong, my lord. This honorable court may
can
restrict not to
say-
exercise the
All right,
jurisdiction.
we can say that it is
And
maintainable.
so far as 10 is concerned, my lord, I will explain, my lord, why I will not avail the alternative remedy, my lord. Here, my lord, 10A speaks that a termination order is to be issued prior approval of the director of. There is no case, my lord. The secretary has issued a notice that you have violated, you have doing private tuition, my lord. He is a lecturer in English, my lord. To that, my lord, I have filed my reply that I am not doing any private tuition. Thereafter, my lord, order of termination has come. No, my lord, proceeding has been initiated. No departmental proceeding was initiated.
So where is
No charge has been framed.
Just a minute, where is the order?
My- Your lordship will kindly see page 42, annex 17.
So where is the inquiry report?
No inquiry report.
It's a private institution.
But it is aided educational institution.
Yes, what kind of order is this? You are appearing.
Inquiry after inquiry
Index.
report and after the direction has been issued by the authority to take stern action against the appellant. Now this impugned order has been
Where is
passed.
the inquiry report?
My lord, your lordship kindly this memo of compensation.
File your affidavit.
Then I will file.
Issue notice. Mr. Judicial and Counsel accepts notice on behalf of respond number
3 and 4, my lord.
3 and 4. AGA accepts notice on behalf of 1 and 2. Stop. Next is the impugned order. The order is impugned in the present intra-court appeal. Was passed by the learned single judge without any counter affidavit. So let's counter affidavit be filed on behalf of respondent number 3 and 4, dealing with the averments made in the writ petition. This matter on 4 weeks for this set purpose. Weeks.
Item number 3.
Item 3 may be taken up along with case at 2 p.m. special list, my lord.
What is this?
That is the block pension of block grant employee.
All right.
Sarath Paridak.
Sarta product.
So you will have to be, see the concept of block grant, you will have to explain.
Yes, my lord.
Because I don't,
No, my lord, your lordship has fixed it today for fixing a date, my lord. Only this today will not be,
All.
because
Which is that item?
item 3 will be at
Special list, all right.
specific.
but I'll try to understand at 2 p.m.
But today, my lord.
No, only,
Just
only what.
give
Yes,
the
yes,
idea.
yes.
Just give the idea.
Yes,
block
yes.
grant means what block, what grant, who
Yes,
grant,
yes.
these things. So basics.
Item number 4.
Item number 4, my lords. On behalf of the conducting council, I prefer an adjournment.
When?
As your lordship pleases, my lord.
As requested on behalf of the petitioner, list this matter on 4 weeks. Yes.
Item number 5.
Deeply obliged.
Please, my lord. In this case, the appellant has challenged the order dated 24/6/2024 of the Honorable Single Judge Miller.
So caveat has been filed in this case.
I'm there. He has served me a copy. I'm there.
Come this side.
No, sir. In this case, I think by order dated, no, sir, 30th of July, Lord, directed to obtain instruction, Lord. Lord,
July, 30th of July.
Read that. It is from.
We have not mentioned anything, but
30th of July, I think your lordships were in session of the matter.
yes.
Lordship had directed instructions be obtained. So
All right.
we have written a letter. We have not obtained any instructions.
This is regarding what?
This is regarding cancellation PDS retailer receipt of the petitioner, my lord. Fact of the case is that he was appointed as the retailer of PDS center of Jaguli Gadia Retail Center under Mukundapur GP in the district of Jaspur on dated 7/8/2021, my lord. And thereafter he was continuing there. And Honorable the learned collector has cancelled his retailership on dated 23/3/2003 that he is not entitled to be the retailer because his father was earlier the retailer of that center and he was disqualified. For that, he is not entitled to get as per clause 6 and 9 of the advertisement. The plea of the petitioner in that case was that he is staying separately from his father since long, and he has provided the partition certificate of him, which was given by the panchayat before the collector.
Not your father.
He is my father, but I am staying separately from my father. The plea of the petitioner.
Always we are coming back.
Okay.
Item 5.
Page 37, paragraph 18 is the reason given for not entertaining his application.
Page?
Page 37, paragraph 18, Milos. From the said report.
37.
Page 37 of the appeal memo, Milos.
Page 30.
37, Milos is
Why don't you give us the internal page of the judgment?
internal page of the judgment is 23 Milos.
Yes.
Paragraph 18. From the said reports also other documents available on record as well as pleadings of the parties and detailed above. This court is of view that the petitioner being the son of Mayadhar Mahapatra, whose retail license was cancelled because of various irregularities
and being a unmarried person and residing under the same roof, as per the statement of his father, was ineligible to apply for the appointment as PDS retailer in view of the specific bar under the said advertisement. His application for appointment as a retailer for regulation should not have been taken into consideration by the licensing authority, and as such, license has been obtained by the petitioner making the false statement and suppressing material facts. That's why.
Yes, Mr. How much?
My lord, so far sub-collector is concerned, so far
There is a finding,
my lord.
just the rule. Where is that?
On the basis
requirement?
of which he has been disqualified, which is that?
Pursuant to the advertisement,
So where is that advertisement
Yes.
which?
my friend has not annexed that advertisement. Only he has given the copy of the.
Okay, the
No,
writ
there
petition is
must
there.
be, there must be control orders or orders.
The
Yes,
writ
ma'am.
petition is there.
That is annexed that advertisement in my counter affidavit. which
The
I
writ
filed
petition.
before the honorable single judge.
All right, that is there. So what is that?
There are two.
No, D by 4.
My lord. B by 2. B by 2 at page 23 of the counter affidavit filed by me.
So you are who?
25/4/2020.
So you were opposite party number?
My lord, I was.
6, my lord.
6. At my instance, the appeal was filed.
Got the say, got it. Why have numbering of your annexures was incorrect? So which is that annexures? Please repeat.
Annexure B by 2 at page 23.
Should have been A by 6, B by 6, C by 6.
That was my mistake. I given the.
Not
just one-
expected of a counsel of your experience. Okay, Oriya. So which one?
No, no.
5.
Fine. There are two clauses.
Arthika
First clause
Sthiti.
is that he should be financially sound. Once his father and his mother, sister are taking beneficiaries of a scheme that is Antodaya scheme, they cannot be called as financially affluent. Second,
He has not taken, but his family members have
family
taken.
members. are-
Second one, show us.
Second one is, my lord, that he should not have been held convicted.
Read it.
Yes.
Darkhastakarini. That one.
Yes.
9.
My lord,
Yes.
কিংবা
Please
তাঙ্ক
read
পরিবার
it.
সদস্য
Read it slowly.
Yes. দরখাস্তকারিণী
Yes.
স্ট্রোক দরখাস্তকারী কিংবা তাଙ୍କର ପରିବାରର ସଦସ୍ୟ
Retail license.
ଲାଇସେନ୍ସ ପାଇଛନ୍ତି ଏବଂ ତାଙ୍କର ସାଧାରଣ ବଣ୍ଟନ ବ୍ୟବସ୍ଥା ଖାଉଟି
ଦ୍ରବ୍ୟ
ତୋଷାବାଦ
OTPDS.
ହୋଇ
OTPDS.
ହେତୁ ପ୍ରଦହି
But acha.
ତୋଷାବାଦ means ମାନେ irregular. His father was
Got it.
and the honorable single judge has quoted that finding of the inquiry officer and found that. My lord, even if he says that I am separate, let us, for the sake of argument, hold that he is separate. It is not separate. Panchayat cannot. Even if hold separate, can he disown his father?
That is why the question.
Yes, my lord, honorable Chief Justice has posed the right question. That can you disown your father?
And incidentally, when did he disown his father? After the incident or before?
My lord, father was removed. Father was found having enjoying, he himself, the retailer, is enjoying 4 cars. 4 cars.
Yes, that is all right, whatever the ground.
And your lordship will see the honorable single judge has quoted that also.
You have said that.
Yes.
Just out of curiosity, when did he become separate from his father?
Well, he said I be separated from the father.
When?
since 2017, my lord.
And his father gives the statement, no, we are under a one roof. His own father gives that statement.
Has to be own father only, not anybody else's father.
That has also been dealt by the honorable single judge.
It's a detailed order.
All right, how much?
My humble submission before my lord is that,
No humble submission. How much?
my lord, I am staying separately since 2021.
That has been found to be false by this court.
My humble submission on that point is that That was a statement before the officers who had gone for inquiry. But in affidavit, I had submitted the partition that Panchayat Faisala before the learned collector.
You can seek a declaration from
My lord.
the civil court. But for the present, you will have to pay something.
And you claim to be financially sound,
My lord.
so payment will not be a problem.
How much? Oh, then we'll.
And continuing properly selected by the sub collector, my lord. So far,
The appellant in the present intra-court appeal has put to challenge an order passed by one single judge of this court dated 24/6/2024, passed in WPC number 11208 of 2023. Full stop. The petitioner, pursuant to an advertisement issued by the sub-collector Jajpur, had applied for PDS license as a retailer of Jagulai Gadia Retail Center. Full stop. He was granted license and was thus allowed to function as PDS dealer. Full stop. Which is not in dispute, that a writ petition was filed. It appears a writ petition was filed giving rise to WPC number 40906 of 2021 for quashing the said selection process which was disposed of by an order dated 9/11/2022, the inspector to dispose of the representation filed by the writ petitioner.
that was the opposite party number 6. That
Petition therein.
Writ petitioner of that case. Stop. The said writ petitioner had approached the court again challenging the said writ petitioner, who is opposite party number
6, my lord. Opposite party number 6.
had challenged grant of license issued in his favor, which was dismissed, but with an observation, dismissed as the order granting license was applicable.
My lord.
Yes. Stop. Respondent number 6 took a plea in his appeal that the appellant is the son of Mayadhar Mohapatra and he was found guilty of availing AAY card. What is AY?
That is
no, there's a.
Anno Uday Yojana.
Todaya Arna Yojana, my lords.
That is
In the
pre-license.
name of his daughter and wife during his relationship, retailership of Jagulia Gadia Retail Center. Full stop. The appellant asserted before the learned single judge that the retailership license of his father was suspended and the entire cost of PDS communities availed by AAY card holders was also deposited by his father, and his father, being a PDS license holder, had not misappropriated the PDS stock without distributing the same to the consumers. So, where is the advertisement?
Advertisement, that is
Annexure B
C
by 2.
B by 2, that is running page 23 of the counter of the opposite party number 6, my lord.
Which annexure?
B by
Page 23 of my counter affidavit.
What is that? What is that? What does it mean?
One is that clause number 5
and 9. 5
and 9. 5 says, Pramana something.
He should be financially sound.
Huh.
My lord, Honorable Single Judge has also quoted that portion in paragraph 14.
Should be financially sound, but they had taken his father and sister. Mother and sister had taken cards regarding that. Okay.
He was the retailer and he was the card holder also.
That was one of the reasons for removing him. But this also because of him, so he claims to be financially sound, but 3 members of his family claim to be below the poverty line for which.
But
that is on ground.
till 17/11/2021, both father and son were getting the benefits of labor employment under Manrega scheme.
Manrega scheme also.
Son also.
Son also. That is also finding of the this Honorable Single Judge at paragraph 14. Specific finding is that.
So basically, violative of clause 5 and 9 of the advertisement.
Yes, exactly.
And that those facts were also suppressed in the affidavit given in the application.
Application for appointment. So which clause requires the affidavit?
No, when they apply, as per the application, they have to submit the details in a format.
Yes.
Which they said that no, we are financially.
So why did you say affidavit?
No, that was in shape of a format it is given.
Is it an affidavit? Okay.
Format.
So in his application. Paragraph 14 and 15 of this order of this learned single judge.
But paragraph 14, under single judge has subparagraph it as paragraph 15, 16, 17 and 18.
Paragraph 17 is there.
Internal page 18. Internal page 18 of the judgment challenge.
He is quoted.
Quoted.
Yes. From your counter affidavit.
Yes. If your lordship sees that subparagraph 18 at running page 19 of the internal page, that if the petitioner as well as his father are working as laborers till 17/11/21, then there is a clear violation of clause 5 of annexure H by 8. Clause 9 clearly states that if any relations of the applicants have been removed on the ground of misappropriation of PDS commodities, which is a real fact in the case of the father of the petitioner, then the very application is to be. The petitioner is thus not qualified under clause 5 and 9 of annexure H by H.
That is the submission of the opinion.
It is noteworthy that admittedly one of the terms, one of the condition for grant of license as prescribed in the advertisement was that the person should have should be financially sound. And relations of the applicant should not have been terminated. Relations, the relators, the
Family members.
relations of the applicant and dealership license of any close relative of the applicant should not have been terminated.
Of the-
Applicant.
Any of the family members, Paribara Sadasya.
Hmm.
Family. Purbaru retail
Of
license.
Accordingly, the learned single judge has noticed the admitted facts that the petitioner's father, his mother, and he himself.
No, myself, not.
Sister.
Your father,
Sister.
mother, and sister were availing the schemes under
AAY.
Give the full form.
AAYY. Availing
Antodaya Arna Yojana Millers.
benefit of Antodaya Anna Yojana bracketed AY as also Manrega.
He and his father were the laborers in Manrega. Mother and sister were not.
And-
Mother and sister, father were under the AAY.
Further, the petitioner's father and the petitioner himself was
Registered.
Registered beneficiaries under the Manrega scheme.
under Manrega.
But my humble submission on that point is that at the time of advertisement, when I was appointed, at that time, I was not the laborer in Manrega. Previously, I was.
But had you denied those,
Yes, that is in sub-collector's order that has been reviewed.
in the writ petition, the specific thing is you have not denied. Though you have filed rejoinder, you have not denied those allegations.
To a petitioner, in the writ proceeding, had taken a plea that he had separated from his father before he had applied for the license.
The year 2017.
My lord, since 2017.
In the year 2017. Full stop. The said fact has been found to be false based on the analysis of on record by the learned single judge. Full stop. Learned single judge has taken into account the fact that the petitioner was, that the appellant was registered under Manrega
My lord.
till 2017. Till 2017
No,
or on the
Till 2021.
17/11/21.
till 2011, 2021,
17/11/20.
17/11/2021. So based on the inquiry reports, it was based on certain inquiry conducted, it was found that the father, that the petitioner appellant was living with his other family members, that is father, mother, and sister. Stop. Having after having taken note of the aforesaid circumstance, then single judge reached a conclusion that not only that various irregularities were detected, the appellant was found to have suppressed the fact and wrongly represented at the time of making application for grant of license that he was financially sound. Full stop. After having taken note of these facts, then single judge declined to interfere with the order of the sub-collector whereby
Appellate authority.
order of the collector whereby the appellant's license was ordered to be cancelled. Order license to run PDS song was cancelled. Stop. After having gone through the impugned order and other materials on record, we do not find any merit in this appeal, since we are of the view that the order passed by the learned single judge is well reasoned, taking into account the pleadings and other materials on record. So the appeal is accordingly dismissed.
Item number 6.
That will correct. The point is that we have one order. Which is order. Instead of the discussion, it has been
Yeah, retribution is zero. Yes.
Item number 6.
Filed against the impugned judgment dated 25th June 2024, passed by Honorable Single Judge. And the judgment, impugned judgment is at page 21 to 49 of the writ appeal.
Yeah.
The last part, 49 of operating part,
Yes.
para 35. Ergo, this court does not find it necessary to interfere in the departmental proceedings and the penalty levied therein against the petitioner. Accordingly, this petition is dismissed. This is the impugned judgment. And may I be permitted to give the facts of the case?
Facts of the case.
Fine. First of the case is appellant and when as a clerk on 15th July 1977 as clerk. On promotion after promotions in officer grade, he reached the scale 4 and posted as Assistant General Manager at MCU Parliament Street, New Delhi branch. Retired also from the service with effect from 1st June 2015 on reaching period of superannuation. He got all his retirement benefits such as gratuity, leave encashment, and pension with effect 2015. 33. He received a memorandum thereafter. He received a memorandum dated 16th June 2016, page 52 of writ appeal and page 25 and 3 of the WPC for a ready reference.
How do you challenge
I'm telling grounds, sir, I'm coming. Grounds, I'm coming. This is very important.
We will,
Random. They have writ appeal, they have not mentioned clearly, but in writ appeal it has been mentioned. So I'm press ready reference. I'm passing on this to memo exactly what is the memorandum says.
so whether this document is there on record or not?
Yes.
Where?
Absolutely, I mentioned it. That is in annexure 3, page 25 of the writ petition. This memorandum. Otherwise, I would not have given this. Memorandum says, dated 16 June 2016. As it has been made to appear that Sri N. Paddy, ex-Assistant General Manager, AMCU Parliament Street Branch, New Delhi, since retired under New Delhi Zone while functioning as Assistant General Manager of AMCU Parliament Street Branch, New Delhi, during the period from 7 May 2012 to 31st May 2015, and had allegedly committed various acts of omission in sanctioning and disbursement of credit facilities to AVC Electric Private Limited, which was sanctioned term loan of 4 crore 30 lakhs as cascaded limit of 3 crores on 31st December 2013 as per enclosed statement of allegation and article of charges, which are construed as grave misconduct. It is proposed to hold departmental proceedings against the N. Paddy as per the procedure laid down in Regulation 6 of Ecobank Employees Appeal Regulation as amended. Now, therefore, in pursuance of the power conferred on the undersigned, Regulation 48 of Ecobank Employees Pension Regulation as amended, the undersigned is directing Sri N. Paddy to submit a written statement of his defense on enclosed article of charges and statement of allegations within 10 days.
So why are you showing this?
No, I am telling you this. They have issued this memorandum. If the appellant has retired, the officer's conduct regulation and disciplinary procedure regulation is not applicable to them as per Supreme Court decisions. May I pay my...
That matter is still pending before Supreme Court.
No, been decided. Supreme Court judgment, I have Supreme Court judgment.
Which is the date?
I have encroached this writ appeal.
What is the action which has been taken on against you?
No, that is a Supreme Court judgment, I have page 54 to 64.
What is that?
Annexure 3, Supreme Court judgment, they say clearly that once the employee is retired.
Is that in respect of UCO Bank?
Yes,
employee?
yes.
That decision?
Yes.
Of Supreme Court?
Yes. That's I'm telling. Once it is retired.
All right, let us see. Where is that?
That is their Annexure 3, page 50.
This is the matter which has been referred to larger bench. Where is that?
Page relevant page 54, 2007 6 Supreme Court cases 694, Ecobank and another versus Rajinder Lal Kapoor. Could you get sir?
Which paragraph?
Relevant para is 22. Paragraph. (22) page 63. The resident having been allowed to superannuate only a proceedings inter alia for withholding his pension under this pension regulation would have been initiated against the respondent. Discipline and appeal regulations were thus not obstructed. Consequently, the charge sheet, the inquiry report, and the orders of punishment passed by the disciplinary authority and the appellate authority must be held to be illegal and without jurisdiction.
So where is the provision for in your regulation?
No such regulation. This is only now Ecobank employees and conduct regulation is not applicable. Only pension regulation is applicable. And pension election, they have kindly come to 48 regulation. I'm giving you the.
Do you have the regulations with you?
Pardon?
Do you have the regulations with you?
Yes.
Where is that?
Para 40, page 66, annexure 5 of RETA. Para page 66, annexure 5.
All right. Show us one statement.
Yes.
Where you have mentioned that under the regulations.
Yes.
Punishment cannot.
Punishment cannot be given. Penalty cannot be imposed. I'm telling you, I'm reading, sir.
Where are those regulations? We want full regulation, full body of regulations, not only part of it.
This is regulation.
Entire regulations are with me. I had filed before the single judge. I was appearing there. I'm having, my lord, that page I have also flag marked. Lordship wants can see it, my
48.
Mr. That we are seeing. We want you to tell us whether there is any provision under the bank regulations, service regulations, that even after retirement, punishment of dismissal can be imposed.
No, it's not dismissal punishment. It is not dismissal punishment.
What is the punishment?
Punishment is reduction of pension by 1/3 basic pay with immediate effect for a period of 2 years. That is the punishment under pension regulation.
That is the punishment which has been imposed on you.
Yes, that is under challenge, and I went also have challenging it. 48 says recovery of pecuniary loss cost to the bank. 1, subsection 1, the competent authority may withhold or withdraw a pension or a part of pension thereof, whether permanently or for a specified period, and order of recovery from the pension of the whole or part of any pecuniary loss cost to the bank if in any manner or judicial proceedings the petitioner is found guilty of serious misconduct or negligence or criminal breach of trust or forgery or acts of done fraudulently during the period of his service. Admittedly, during his period of service, this memorandum has been sought. That allegation sought. Then, that is also within 4 years of from the date of retirement. That is no dispute about that. Then, this under 48 regulation 1, proviso is there, provided that the board shall be before any final order are passed, provided further that departmental proceedings, if instituted while the employee was in service, shall after the retirement of the employees be deemed to be proceeding. It is not applicable. Only the first provision is important and relevant and vital. Provided that board shall be consulted before any final order is passed. And there is no consultation, there is no evidence for that. Without any evidence.
Board was not consulted.
No. So this punishment cannot be sustained at all. This is my whole feeling. Another is, the very heading says, recovery of...
What is your submission? 1, that board was not consulted. 2,
the punishment cannot be given.
So that is the only ground.
That is other. This is the ground.
Okay, this is the first ground.
Second is recovery of
punishment cannot be imposed. Why?
Because they are not consulted. They have to consult board approval.
Therefore, that is one point.
Yes.
What is the other? Any other point?
Yes, there are so many other points. I am telling you.
No, forget so many other points. One, your most important point is that the board was not consulted.
Yes.
So the punishment could be imposed after your retirement.
Could be imposed.
All right.
Provided board has approved it.
All right.
Number 1. Number 2, loss. If there is a loss, that has to be proved through departmental proceedings. Then only the other things, this regulation will be applicable. And in departmental proceedings, nowhere, either in a statement of allegation or in departmental final order, loss has not been mentioned.
Even in the absence of any loss, this punishment can be imposed. Yes. This is the language, clear language.
No, it is so, recovery of pecuniary loss.
Please read it full.
Yes.
The competent authority may withhold or withdraw pension.
Yes.
Or part thereof. or for a specified period.
Yes.
And order recovery from pension or of the whole or part of any pecuniary loss.
Yes.
So there are two situations. There are two things. One, your pension can be withheld, and two, can be recovered for the loss.
Yes.
So both.
Yes. But there is no proof of loss, number one. Then in that case,
Even if
another
there is
case,
no proof,
board has to be
any
consulted.
misconduct.
Say it is not required. Why do you say where does it say that proof has to be there? Or that is your submission?
Submission, loss is not there mentioned in the statement of allegation or even final order. Through departmental proceedings.
You mean to say the loan which was given that has been returned?
No, no
Then-
loss has been identified, quantified, and certified. It has to be brought to the notice of the petitioner. It is separate adjudication. He has to be hired.
See, the misconduct has been established.
Yes.
Once the misconduct has been established, even if there is no loss,
Yes.
pecuniary loss caused to the bank, the punishment can be imposed. That is imposed.
But provided the board is consulted and given.
Board should have been
That's
consulted. You were there, you are right. Whether the board was consulted.
One moment. My lord, let me explain it. In the writ application, the first ground he had taken that this disciplinary proceeding has been
No,
initiated.
forget ground or.
That 48(2), I'm having the entire regulation, it covers. And the punishment imposed is 1/3 of pension. That is in 48(3) of the pension. Now that is one part. The second part, my lord, he told that the disciplinary postings, the High Court will act as an appellate authority. There, the Honorable Single Judge has told no. As per the law laid down, he had given one decision, P. Gunashekar, I have got that. There are other decision, your lordship knows, I did not. Now the third part is, my lord, the consultation of the board part, which he is saying, that is correct, my lord. But in support of that, I want to give a decision to your lordship. That is Haryana Financial Corporation and another versus Kailash Chandra Ahuja. There, the apex court had held. If that was a case where inquiry report was not, that was the background of that case, my lord. And the High Court had said that that is a violation of natural justice. It is writ large and it is set aside. But it was reversed in the apex court holding that, my lord. I'm just reading, my lord.
Prejudice.
Yes, doctrine of prejudice.
The prejudice, see, it's a question of competence. The board might have taken some other decision.
My lord, board has only to give a formal permission, my lord. Board, there is neither the disciplinary authority nor the appellate
required
authority.
to be consulted.
So that is my answer to that query. The other parts are covered by the judgment, my
Other
lord.
parts, yes, we agree. But
At para 24, the Honorable Single
without
Judge has held.
consulting the board, if your in fact, the disciplinary action should have been initiated against the disciplinary authority for not placing the matter before the board.
My lord, there the question, as your lordship told, your lordship knows of prejudice. Ultimately, would it have made any
There is
difference?
no question of prejudice. That is the requirement.
My lord.
That is an essential requirement for you to take a decision.
I bow down to your lordship, but here is a case, my lord, on which I'm referring. The prejudice was even heavier, my lord. Where the inquiry report was not given.
If a person who has competence to pass an order, if he passes and a plea is taken of violation of principles of natural justice, then question of prejudice will arise. Here the person did not have the competence.
No, my lord, it is not a question of, he is not saying it is a competence. He is saying consultation. Your lordship may kindly
Consultation is
appreciate.
incompetent. His decision is incompetent without consultation. This is what we are saying.
My lord, that is certainly one aspect. Your lordship can take that view. I cannot, my lord. But my humble submission would be, my lord, twofold. That the consultation with the board, my lord, the appellate authority nor the disciplinary authority, it could not have passed any orders. That is, my lord.
Sir,
and the second part is this decision. Ultimately,
the submission which you are making is against the regulations and is against your own institution.
my lord, what is on facts, I cannot dispute before your lordship, my lord. That is correct, my lord. The board was not consulted. Because otherwise we would have filed it in the counter affidavit. I had asked that specific query to them also. That is not in dispute, but that is only twofold submission I can only submit for your consideration of your lordship. Is this decision which I'm relying upon, my lord? I'm having only one copy. That, my lord, that ultimately two things, no prejudice, and it would not have changed the fate of the case.
How do you know?
My lord, because this is the power of consultation, my lord. Consultation, in the sense, my lord, it is since like an approval, my lord. It is not that they could have passed any further order as an authority of the appellate authority.
Remove it.
No, one thing you can say that,
My lord.
okay, before taking a decision, you have not consulted. Had you done it thereafter also, then also maybe you would have saved it.
Yes, post-decisional, your lordship is saying.
Had that been
No,
done?
my lord. Unfortunately, in that, not there. So I cannot, my lord, digress from that.
So
But
this is
my reply will be this to what your
listed
lordship.
for fresh admission or disposal?
This is for fresh admission.
You have appeared suo moto.
Yes, my lord. I was appearing in the court below and I have got Wakalatnama with me.
So whether this plea was taken by you
Yes.
in the writ proceeding?
Yes.
That the board was not consulted?
Yes.
What is the answer of the learned single judge?
See, they had not, they had
My lord,
completely
we'll
ignored
see
this.
internal
They have
page
not taken into
21 at
account.
para 24.
This
This
provision,
aspect the single judge has not dealt it. At para 24, the other two submissions found favor, my lord. At
They have
internal
just
page
ignored it.
21. From there, the court's reasoning and analysis flows, my lord.
The liberty to the bank to place the matter with the tomorrow we will dictate what.
My lord,
That
may I
line. We will
submit
give
that-
you permit. We will permit you place it before the board in accordance with 48 and take a decision. It is
yes,
not that.
but this minor regulation says prior to imposition of penalty.
Therefore, we shall be quashing your penalty order.
Yes.
And we will be directing them to
That is
permitting them to.
that is already retired.
Huh?
So this is for retired people only, the regulation is there.
Yes, my lord. Your lord, because the lordship knows generally after retirement, discipline proceedings cannot be initiated or continued unless there is a provision in the regulations.
Yes, almost in all service.
That your lordship knows there is a regulation which permits, but there is a time limit of 4 years. If that event has occurred within 4 years of his retirement,
That I am not
then that can be.
He's not saying that.
No,
He's
in the
very
writ
reasonable
application,
in his
actually, that was his.
Mr. Counsel,
that is not happened in dispute.
he is very reasonable in his submission. He says that this punishment can be imposed.
Within
but he
4
says
years
that
from the retirement. That should depend.
No, punishment can be imposed 4 years or the
Department
Can be-
Can be started.
Initiate.
Initiated.
Can be initiated.
Initiated and culminated, ma'am.
And he has
Punishment
put
can be
his best
imposed
point
only
also for-
prior to punishment. They have to get the permission from the court, which they have not.
No permission from the board. They have to consult.
I just said consultation not by rote of notes and submit before the court to have consulted. There is no evidence, document evidence before the court.
Oh, you can dispose it of right now. Huh? We are dictating.
My lord, the judgment can I give to your lordship, my lord? Yes, ma'am. Because that is my only answer to the not following the boards. And that the consultation part is directory and not mandatory, my lord. Only those two submissions.
A judgment dated 25/6/2024 passed by learned single judge of this court in WPC number 15143 of is under challenge in the present intra-court appeal, whereby the appellant's writ application has been dismissed. The petitioner, the appellant, was an employee of UCO Bank and he retired as Assistant General Manager, MEU Parliament Street, Delhi, on 1/6/2015. Stop. He had put to challenge an order dated 29/1/2018 passed by the disciplinary authority,
It's a competent authority.
by the competent authority, imposing punishment of withholding of
Reduction, not
a reduction
of
of
1/3 basic pension.
1/3
1/3 basic pension for a period of 2 years.
of basic pension for 2 years on proved charge of misconduct against him, comma, full stop. The proceeding was initiated against him, the disciplinary proceeding was initiated against him after his retirement, in accordance with Regulation 48. Which page is that?
48 page.
Mixture.
My lord, I have the entire regulation. If you
No,
want.
no, you are-
I'm telling here. Regulation 48 is page,
Part of the reproduction, page
page
56.
66 of writ appeal.
Oh,
And
48
5.
of the regulation.
Pension.
Regulation is Ecobank Employees Pension Regulation.
UCO Bank
Employees
employees
Pension Regulation.
in accordance with Regulation 48 of the UCO Bank Employees Pension Regulations,
1995. my lord.
1995, which reads thus. At page quote कर दो. Stop. Learned single judge, after having noticed the submissions advanced on behalf of the appellant and the bank, reached a conclusion that
Para
the
24.
discipline was conducted following the principles of natural justice, and the appellant was given due opportunity to defend his case. So stop. And single judge accordingly opined in the impugned judgment that there was no requirement of interference with the finding of facts recorded by the inquiry officer, which was based on appreciation of evidence. So stop. Next. Assailing the impugned judgment, learned counsel appearing on behalf of the appellant has submitted that the appellant had taken specific stand that the board, what is the definition of the board? That
Board
no,
is consisting of
no-
directors.
that no final order for reduction of pension would be passed invoking a regulation 48 of the UCO Bank employees, what is it? Pension regulation.
Employees pension regulation.
Board has been defined as means the board of directors of bank as per the pension regulations. 2F of the pension regulations. 2F of the,
That 1995?
again, there are 2F again. Board of directors of bank.
Do you have one copy or two?
Now, more copy again, the entire regulation is there. They will.
Final order of a reduction of pension could be passed
2F may alert.
without consulting the board of directors of the bank. So, right, provide that the board shall be consulted. Second paragraph, first proviso, board. So, we have submitted that the learned single judge has not addressed the said stand taken on behalf of the appellant in the writ proceeding. So, next, learned counsel appearing on behalf of
Both the respondents, UCO Bank.
of the respondents has argued, has not disputed the factual position that before imposition of punishment of a reduction of pension, the board was not consulted. Full stop. He has, however, submitted that the said requirement of consultation with the board is directory in nature and not mandatory. Full stop. He has further argued that in any case, in any event, the petitioner's case, appellant's case cannot be said to have been prejudiced because of prejudice in the absence of consultation with the board. So stop. In support of his submission, he has placed reliance on
2008 9 SCC, that judgment I've given to your lordship. Having one copy, my lord.
Supreme Court's decision in case of Haryana Financial Corporation and another versus Kailash Chandra Ahuja, reported in 2008, volume 9 SCC 31. So stop. This is the only decision?
My lord, that Honorable Supreme Court relied on Karunakar's decision.
That is principles of natural justice.
That I don't have to explain, my lord knows that.
The next, after having heard learned counsel appearing on behalf of the appellant and the bank, we are of the view that the Supreme Court's decision in case of Kailash Chandra Ahuja bracketed Supra has no application as the challenge of the appellant on the ground of non-compliance of the requirement under regulation 48 of the regulations pertaining to consultation with the board before passing of a final order under the said regulation. So stop. The decision in case of Kailash Chandra Ahuja deals with the effect of non-supply of inquiry report. And in that background, the Supreme Court has held that the charged employee must show that a prejudice had been caused to him because of non-supply of the inquiry report. So stop. Next, in the present case, the question is as to whether the order passed by the competent authority imposing punishment of
Reduction
of
one-third
pension
basic pension.
can be sustained, which has been passed without complying with the requirement of consultation with the board under the first proviso, required under the first proviso to regulation 48 of the regulation.
Clause 1, my lord.
48
Clause 1. There are three clauses there.
48 1 of the. So stop. Next. On careful scrutiny of the provision under regulation 48 bracketed 1 of the regulations, we are of the definite opinion that the requirement of consultation with the board is mandatory in nature, as is evident from its language itself. So stop. The first proviso mandates in no uncertain terms that the board shall, quote unquote, be consulted before any final orders are passed under 48 1 of the regulation. So stop. The question, the impugned order having been passed without with the board, in the court's opinion, impugned order, the order of punishment dated 29/1/2018
29/1/18
cannot be sustained on the sole ground of absence of consultation with the board, a requisite under the first proviso to regulation 48 1 of the
pension regulations.
pension regulation. So stop. In our view, the impugned order passed by the learned single judge, so in our view, it's a crucial aspect. In our view, since this said crucial aspect has not been considered by the learned single judge in the impugned judgment, this requires interference. So stop. The impugned order, the impugned judgment, so passed by is accordingly set aside to the limited extent that set aside and stands modified to the extent that order of punishment dated 29/1/2018 passed by the competent authority imposing order of punishment is set aside, is also set aside with an observation that the competent authority shall be at liberty to pass an order afresh after consultation with the board as required under the first proviso to regulation 48 bracketed 1 of the regulations. Stop. The we make it clear that this is the only ground on which we have interfered with the order passed by the learned single judge. So we do not find any legal infirmity in the other findings recorded by the learned single judge. On the point of finding of misconduct recorded by the competent authority. So stop. We shall not say that.
Already, this is 24.
Otherwise,
This is 24. Already, so 6 years have already passed.
already we are not saying.
Lordship may fix a time limit.
We have set aside the order.
Time limit.
We expect that the will complete the exercise of consultation with the board within a period of 2 months from the date of receipt / production of a copy of this order. There shall be no order as
Urgent call.
no urgent copy.
Urgent call.
You'll get it without the order.
Because your lordship have fixed a time.
Therefore, we want to know whether you get the certified copies within time or not. So if you don't get it, you come and complain in the that you have not been able to get a certified copy within maximum a week.
Generally, those occasions never arise as far as our registry is concerned. It may be a few odd occasions. They are overworked.
It will never happen. And you can file online, file your application online.
No. Sometimes, my lord, the online copy is uploaded, but the certified
No
copy
question of
sometimes it is
uploading.
delayed.
You will get the copy online. Certified copy, if you apply online, you will get it within 1 day or 2 days.
I'll do that. My lord, I have filed my power also, my wakalatnama today. That may kindly be taken on record. Deeply obliged.
Item number 7.
In item number 7, here notes, this relates to rejection of an application of a convict for premature release. There lordship were pleased to direct me to obtain instruction. I have to obtain instruction. I prepared the draft counter affidavit. Some more time so that I can get it. 2 weeks time, lordship will
2
grant
weeks
me
time
for
is
that.
allowed for the Portland AGA to file counter affidavit. It's just 2 weeks.
Small admission matter. Oh, lordship, may It may be taken up today or tomorrow.
Maybe
Item
small for you.
Let,
Maybe small for you.
let that IJR admission matter, third round counseling is started today. Hello, third round counseling is
Admission to
to BS and MS course, Bachelor of Science, and the examination conducted by IJR, Indian Institute of Science and Research.
So there is a last date. So it is
Third round counseling started today.
who is for the other side?
fresh
Not
admission.
the central CGC,
Fresh admission.
Central Government Council.
So we will take up your matter today.
There is another matter, that item 53, batch of matter, Lordship heard this matter in extension, Lordship. So far that virus part, your Lordship said that file affidavit. In fact, in many of the cases, the affidavit have been filed, but some of the cases affidavit could not be filed because some other councils are there. So what do we your Lordship's acceptance? Your Lordship segregate those cases, those who have filed affidavit, your Lordship can reserve for the judgment. So that if somebody will come forward, file affidavit, otherwise their cases will be separate.
Virus.
Virus.
That virus matter, that 6 years, counting of 6 years service period.
No, no. See, are you submitting that in some of the cases they are pressing the virus issue and
They
some
are
of the-
not pressing, but they have not come forward to file affidavit as we have already
This
suggested.
process, what happens? The matter is already adjudicated, Lordship hard it in extension. So getting lingered unnecessarily because of non-filing of affidavit by them.
So in those cases, your Lordship detect from those cases.
All right, we'll inquire.
Yes.
We'll see today because that non-filing has not come up. Today we'll see if anybody is filing.
Yes, no, that's right. We can also make a list also.
Non-filing cases are also there.
That is what,
Yes.
Also file.
Arise, if that virus part goes. to
Single
that-
judge.
Yes.
That is not the.
No, but simultaneously if we do, if we
If
do it,
Chief Justice is not.
if-
has not disclosed.
That problem may arise because if that virus part goes, then it may.
after
Yes.
hearing
See
for
that.
3
Yes,
days.
that particular.
matter.
Reason that the Honorable Chief Justice is representing that naturally it can be. And matter was hard in extension.
Item 71, the Lordship said posted it at 2 p.m. My learned friend has some instructions.
My Lordship, I received instructions in that case that the tender has been cancelled. I'm appearing on behalf of the tender authority, Orissa Computer Application Center. The impugned tender has been cancelled by them. My Lord, the writ petition and the PIL was challenging the tender itself.
So that
Let us see what is there.
becomes infructuous then.
Yes.
My Lordship.
We can record that.
Same matter.
My-
You say same matter.
Same.
71, that council is hearing on behalf of the
United
states that in the tender notice has cancelled. This rate application has become infructuous. This application stands disposed of as having become infructuous.
Lordship, we reserve a right to challenge the cancellation. If we find it illegal, because we just informed, we just want to reserve our rights to challenge the cancellation.
No, who are you?
Yeah, Lordship, we were the private
We were the respondents.
respondents who
We
actually
had
were
participated in the tender.
tender and were eligible also.
It goes without saying that the parties aggrieved with the cancel. The tender notice shall be at liberty to take recourse to appropriate.
Legal.
Shall be at liberty to appropriate forum in accordance with law.
Probably little more to my lord's lord. In that item number 53, can I request, all of us can request to my lord's lord, sometime next week at 2 p.m. so that this matter can be sorted out.
All right.
No, but once we don't know if anybody is
I will
going to give or not.
try that, find out the
2
list.
PM, by 2 PM, everything will be clear. Sorry, by next date, everything will be clear.
Sorted out.
So 2 affidavits have come today.
Yes, Lord.
3 have come today.
Last time I registered.
Last time on my behalf, on my office, it was filed about 20 cases we have filed.
Better.
Wherever I am appearing, we have also filed.
The registry reho.
Okay, of course,
Both will.
that one matter is a special list that regarding that block grant employees pension matter. Lordship has directed that list. I have given another list also to the court master. This is regarding the school matters. Principal is same. That is, this is regarding school teachers, and another list regarding teachers of colleges, teachers and staffs of the colleges. So I have issue is same. That matter has also not come along with that list, because this list, today's list.
I have a prayer in that case because I'm appearing for the respondents. State has filed. But so far the schools case are concerned, schools about more than 500 schools.
I have given
some cases. So let us segregate, because the set of argument which will be advanced in case of schools is different
right.
than the yes.
All right. Let us decide one set.
Yes.
And thereafter we will take up the later.
Yes.
That principle applies in the other case also, we shall apply.
That's right.
Yes, that would be better, my lord.
That would be better.
So what is this block grant?
Block grant means, my lord, earlier that as per the.
Please, Mr.
Yes, Lord. The question for consideration, there are different type of
question.
Block grant.
Yes. Block grant is a block grant.
You are addressing a judge who does not
No,
have any idea.
I am not in favor of any party now.
About what is block grant?
So for the block grant is
we are not doing anything. We will just adjourn the matter. But just I want to have the idea of what is block grant.
Sir, there is a entire history. I don't want to put that history because so far the aided institutions, private aided institutions are concerned in the state of Orissa. Initially, there was no statutory rule. There was executive instruction. By virtue of that executive instruction, they are receiving aid. And aid means they are under the executive instruction that whatever the salary components of a teacher, that will be dispersed through granting aid 357. Then after completion of 3 years, 1/3. After completion of 5 years, 2/3. And after completion of 7 years, full salary cost. That will be applicable in respect of women's college. So far as the degree, all other colleges, that will be 579. That principle. That was granting aid.
That which
yes, that was prior to 1694, because 94 granted for the first time the statutory rule came into force on 1694 pursuant to a provision made under the Orissa Education Act, Section 7C, subsection 4. Pursuant to that act, it was said that all granting aid to be released only on the basis of the rule or order or executive instruction to be framed pursuant to that Section 7C4. After that, that is Act 13 of 94, that was incorporated. Subsequently, they made this 90 to that provision. There also they said that those who are receiving granting aid, they will be allowed to receive. They made the categorization. Category 1, Category 2, Category 3. Category 1, those are already received the granting aid. They will go on receiving the receipt. And Category 2, those who have received, those who are eligible to receive grant after 5 years, by 1694, they are coming under Category 2. They made that they are allowed to receive the granting aid. So for the Category 3 is concerned, after 1694, after the 94 granted order came into force, that on completion of 5 years subsequent to 1694, they will get 1/3, 2/3 like that. But while they are receiving the granting aid, in 2004, this block grant concept was incorporated by virtue of an executive rule, where the 94 granted order was repealed. And in 2004, and for exercising the same power, Section 7C4, same power, they repealed the 94 granted order and they introduced this 2004 granted order, that is by way of block grant. What is block grant? They said in the rule that it has no linkage with the salary of the direct, it cannot be paid to the directly to the teacher. Then that there is some confusion there, there is some judgment. They said that this is the block grant concept, means they will give it lump sum amount to the management and that will be dispersed to the teachers. That is a lump sum amount. Not that the salary as was extended to them and in terms of 94 granted order, that was a direct payment scheme. Under the 94 granted order, that was directly paid to the teachers and the lecturers, teachers in school and lecturers in college.
Employee.
Then in that 2004, again they made, so far the schools are concerned, in 2007, so far 110 gas school is concerned, they made another rule. though in 2004, the 94 rule was repealed, they said in 2007, only will give the notional benefit under the 94 granted order, and so far the actual benefit is concerned, they will get from the so far school is concerned. But so far the college is concerned, what they have made, in 2008, they again repealed that 2004 granted order, block grant. So again, they incorporate 2008, and that applies to 488 colleges. They categorize, sorry, 662 colleges. Then subsequently, 2009, another granted block grant. That is 2009, that was brought into force, and that was applicable in respect of 488 colleges. 488 colleges. Now, subsequently, 2017, they decided again that granting it to all. Granting it to all those who have satisfied the requirement, such and such. That in details are.
So the difference between granting aid and the block grant may be same thing.
Same. Actually, the judgment which has been rendered.
When the amount is released against the salary of individual teachers.
Right.
All right, this is one aspect. And when a bulk, a lump sum is given to a management.
Right.
Or to the teacher or whatever. So that is block grant.
That is block grant.
One is block grant, the other is
Granting aid.
Granting aid.
That is direct payment.
That yes, the difference is between direct payment and block grant.
Yes, that is the only.
Both are granting aid.
Grant.
Yes, sir. Yes.
So now
language is granting aid by way of block grant. The subsequent development is granting it by way of block. But they're the same granting.
The issue where your lordship is now going to decide, that is the 81 rule. It is applicable in respect of employee retirement pension benefit, in respect of the employees who are aided education, who are serving in aided education institution. What is aided education institution? That is defined under the Act, that is section 3B. And that has been now considered by the Honorable Single Judge. If the definition under section 3B refers to an employee of an aided educational institution, and this mode of payment of both block grant and direct payment are the same method that is going to the directly to the teachers' employees' accounts, then you can't make a distinction between a block grant employee and an employee directly under getting the grant. And there is a rule, recruitment rule, that is 74 rule. The question for consideration was that whether the 74 rule applied to the block grant.
The block grant teacher and granting aid teacher, the concept is not clear to me.
Yes, sir.
Because block grant, there may be block grant college or block grant school, but not block grant teacher. Or granting aid school.
Yes.
Granting aid college, but not granting aid teacher.
That is also a background for here.
Yes,
prior to 74, yes, correct. They were giving the grant directly to the management of the institutions, these private institutions. But it was found that those granting aid is being misappropriated in different ways. They are not directly going to the teachers, the employees. So therefore, for the first time in 1974, they, by way of this statutory rule, that was payment.
So that is mode of payment.
That is the mode of payment.
But still the concept of grant in aid is for the institution, so that the institution may sustain. Either by direct payment or by block grant. The grant is for the institution.
Grant is for the purpose of payment of salary.
All right. For the institution, for the payment of salary. Yes.
That is right.
There is nothing, no confusion about it.
And there is that problem of granting aid regarding the post or the teacher. For example, if that post has fulfilled that criteria, then it will come. Teacher may have left some other.
Unless that post is filled up by a qualified teacher, you cannot.
That is only applicable in the case of colleges, not in respect of
colleges.
And that is a provision of the 74 rules, Rule 9(1). Whatever salary will be paid to the lecturer or teachers of the government school, the same scale of pay will be paid to those teachers by way of grant. So these are the issues. Your Lordship rightly put that question to have a broader concept so far the grant and block grant is concerned. But this is the issue to be decided by us.
Then the decision of the
That
black
judgment,
grant order is an order.
that still is under consideration in batch of cases. That is still under consideration. The Supreme Court has passed some orders, and the granted was released under direct payment 94, and subsequently another judgment came. That judgment now that was disrupted. Again, a batch of cases have brought to Supreme Court.
All right.
That
So
would
according
not
to
bear
you,
yes.
it's a complex issue to be.
And the whole problem.
There are
What I
if your
suggest,
lordship will try.
because number of cases have been filed, different lawyers have appeared and different. Though common cause of action, common question involved in all, it's required to go to all in all cases.
This too?
Notice to
Colleges.
the because they have
Choose your
because they are
petitioner in
petitioner within the before the single judge.
Oh,
They have succeeded. Their right is accrued in their favor.
Yes.
Notice has to go.
An alternative submission. An alternative submission, my lord, if I'll serve copy on the who are appeared for petitioners before the honorable single judge, then
That will not make them.
to appear.
Yes.
Some may not.
But
yes, it will be better, my lord, notice it to go in all.
These matters were earlier taken up.
No. It has not been even taken up for
Before
admission.
issuance of notice, let us hear the matter.
One or two cases perhaps notice your lordship was pleased.
The case where my non-friend is appearing, that is a case of college. The first case. That case also tagged with all these cases, if you also will see the interview order. And those cases, both schools and colleges. So naturally notice has to go to.
Right.
जोड़ी दवा କଥା ନା ଅଲଗା ଦଉଛନ୍ତି ଆସୁନି।
So without issuance of notice, we can take up the matter once.
Once, yes.
All right.
Yes.
And once we are satisfied that
Yes,
the
yes.
judgment requires, then we tell you
Right,
not.
right. Yes.
And some of them appear, they may appear. So when do we fix?
Week after.
2 weeks after.
2 weeks after. Oh, I saw it. 2 weeks after my non-friend says yes.
These matters have been listed today. All these cases involve a common questions of law to be decided by this court. Full stop. These have been listed today primarily for fixing a date of hearing on the point of admission. So stop. With the consent of the parties, let this batch of cases be listed on which date?
2 weeks,
2 weeks.
2 weeks after, my lord.
2 weeks. 21st. To be taken up at 2.
53 টা রাখলে next week.
That will do saying then.
1 week. Huh? 1 week.
So that 53 1 week.
53 also may not keep it to 16 because I will not be available on any date after 16.
14.
No, 16 के बाद
14th. 14th.
No,
16, 20th.
Friday.
21st.
21st.
Same day. My item 3 will come with this matter. My item 3 of the supplemental list will come with this matter because this is the similar matter.
Which matter?
Item 3 of the supplemental list.
Come with this matter.
The special list.
Item 3, yes. 40.
Under of the direction, the DFO circuit is present. And I have also filed a affidavit as per lawsuit direction, giving the details of the they're in charge of that office of DFO from the date of passing the order till date. And I have also explained because the lawsuits passed this order because we have filed a review application where we have taken a stand because the state had made an application before the central government under section 26 capital A of that Forest Conservation Act for granting permission declaring the sanctuary. That notification has already been made in 2018, Milords. Declaration of sanctuary, Milords. Now no permission can be granted for cutting of the trees because it comes within 10 kilometer radius of that sanctuary. And the total number of trees are more than 300, Milords. And in my affidavit, I have given the details of this notifications, also central government direction that the eco-sensitive zone is within 10 kilometers from the boundary of that sanctuary.
Where is the order?
Yes, order is also kindly look at it. Page 11, Milos. Initial order 11/2/2015.
So this order was passed in 2008.
15, Milos.
2015, sorry,
Yeah.
2015. What was the order?
Page 11, Losimer, there was a direction for the granting permission to the petitioner to cut the trees from his private land. Milos.
The Union of India did not have any objection then.
Yes. That is why this was given. But by that, then we had made an application for seeking permission under section 26 capital A.
When did you make this?
But that is why I filed a review. The review has also come along with that application number 41 of 2015 itself. That is there along with the contempt petition.
What is the ground for review?
No, that is only if you also can come to ground number C, D. Now there that ground number C. For that is respectively submitted that since government is interested to declare some areas as de-reserve and for which government needs some alternation in the boundary of the sanctuary, Satkosia sanctuary. Accordingly, a draft notification under section 26 capital A has been made and the same is now pending before the government of India for approval. Then, if paragraph D also same, that the only submitted on perusal of the impugned order dated 11/2/2015 in para 1, it appears that this honorable court while disposing the application observed that initially his land was brought within the purview of protected sanctuary, but later on the government of Odisha denotified the area from the protected sanctuary. The apparently error on the face of the record. It is pertinent to mention that government of Odisha has not denotified the area.
Whether you have received notice of this review application?
I've just received in the court itself.
When?
On the last date.
But this review application?
Yes, in 15, but it was received by me in the court itself under your lordship, just in the last date.
My lord, before proceeding further, I request your lordship to see Annex A of the compliance report filed by my honorable.
Please come to D, ground D. Ground D of the review application. This goes to the root of the matter. This goes to the root of the matter. And this review application remained pending since 2015. You did not have any knowledge.
They served any notice to me, nor it was mentioned in the court while the contempt petition was taken off.
Every day it is on the last occasion also it was listed review application.
There's an order there.
Your lordship passed order, it should be given to me. But still then after 15 days it was handed over to me.
Even you should also have the anxiety.
My lord, the fact is that at the time of passing the order in 2015.
Please come to D.
My lord, that it is submitted that on perusal of the impugned order dated next. For one, it appears that Honorable Court, while disposing of the application, that initially his land was brought within the purview of protection, but later on, the government of Odisha denotified the area from the protected sanctuary. Denotified the area means it was excluded from the area. My lord, later on it was denotified from the...
Please read the whole paragraph D.
The aforesaid observation is apparent in of the record. It is pertinent to mention here that government of Odisha has not denotified the area from the protected sanctuary. Now they have done it.
No. They say that this observation made by the court is an error apparent on record.
My lord, both these union, on behalf of the Union of India.
This is what happens when we decide cases on the basis of oral submission.
My lord, but the fact
is what?
My lord, at that time, when the contempt, the order was passed in 6728 WPC.
You file your affidavit to this review application, Wilson.
My lord, at present they have already mentioned that it has been denotified in the year 2018.
Where is that?
The present situation on page 8 of the...
Not denotified, not denotified. Those 104 villages
excluded,
which are within that sanctuary have been notified to be what is that word? Excluded from that. That means
yes, excluded from the sanctuary.
Please wait. It is excluded means what? It shall be within that sanctuary area, but for the purpose of the sanctuary, these areas will be not counted towards the entire area. Supposing this area is 16 square miles. The entire sanctuary is 15 square miles and 104 villages are 10. Then what the sanctuary will be 16, but the area of the sanctuary will be calculated as 5 miles. That is the notification. And if you also have given that affidavit, it is
Sir, you are alleging disobedience of an order which was passed in 2015. The order was passed in 2015.
Right, sir.
The observation which was made by the learned single judge,
not single,
by the court, was incorrect according to them.
But my lord,
so where is the question of contempt of that order?
My lord, now they say that.
Now they say that in 2015 itself they said that.
No, it was not served on me.
Served on me, therefore it doesn't mean that they did not say.
So the Honorable Court also did not take any action on the review petition.
All right. Then file a contempt against the court.
No, my lord. My lord, my prayer is...
What kind of submission are you making?
No, but mine, the present, today I got the reply on contempt, my lord. Reply on contempt today dated to 2024.
Is arranging disobedience of an order passed by this court dated
Challenging
22/11/2009. Oh, sorry. What is the 11/2/2015 in WPC number 6728 of 2008, relevant portion of which reads thus.
But Mr. Samantray, if I'm not mistaken, that original order, which was passed after it was remanded from the Supreme Court, there is an order for cutting the trees. But there is no specific order for removal. But in that miss case, it has been stated we have passed a detailed order on so and so, allowing him to cut and remove the trees.
Remove the trees.
This is not
Originally it was not there, but subsequently it was there. No.
Yes, put it. It is there in the content there. And he's given an annexure also. Annexure 3 is the modification order, and the original order is annexure 1. Peculiar order is only for
Last two paragraphs of the order. Later, miscellaneous case was filed in the said writ petition, whereafter following order was passed by this court on 9/4/2015. Reads thus for 9/4/2015. First off, is noteworthy that the state of Odisha filed a review petition which came to be registered as RVWPET number 41 of 2015, seeking review of the order dated 11/2/2015 on various grounds, including the ground as taken, including ground D, which reads as under ground C and D, which read as under. Oh, stop. Next, it is specific case of the state of Odisha that the observation made by this court in the order dated 11/2/2015 to the extent that the government of Odisha had notified the area from protectory was an error apparent on the face of record. Full stop. Next. Learned counsel appearing on behalf of the petitioner in the contempt petition accepts notice for the respondent in RV WPET number 41 of 2015. Stop. He shall be at liberty to accept or rebut the grounds which have been taken in the review application, seeking review of the court's order dated 11/2/2015, violation of which has been alleged in the contempt application. Stop. Next, we have taken note of the fact that soon after the order dated 11/2/2015, the state of Odisha had filed the said review application, which remained pending for 9 years. Stop. In such view of the matter, OMA, we will consider on the next date whether to proceed in the contempt matter or not, and whether the conduct of the contemners can be said to be intentional/willful. Full stop. Willful in not carrying out this court's order dated 11/2/2015 in the given facts and circumstances of the case. Stop. The respondent number, you are respondent number 1.
Yes, sir.
He is respondent number 1.
Yes.
Yes, only respondent.
The
Sole.
respondent shall be
Sole respondent.
at liberty to
Yes, sir.
list these matters on. When will you file your affidavit?
I pray for 2 weeks time.
2 weeks. We are making this clear that you are alleging disobedience of the order of this court dated 11/2/2015. We shall not take into account any development subsequent to 11/2/2015 for the purpose of entertaining your application, your contempt application. So this we are making it very clear. Subsequently, what happened? We are not concerned with it. They asked on 11/2/2015, whether that was required to be complied with or not. The divisional forest officer, which
Satkosia, wildlife
Satkosia.
sanctuary.
Mr. Suensu Satkosia is personally present.
The name, his
Also,
name, give it.
Yes.
Then an affidavit has been filed by him in compliance of this court's order dated
Dated
37/2024.
yes.
Yes, ma'am.
37/2024. So stop.
Copy on Mr. Naik?
I just
I've given
received
copies to all of them.
He has received.
Today I received.
Yeah.
No, in that content. Affidavit.
Contempt you have received. Copy of the said affidavit has been received by learned counsel for the petitioner. Stop. List this matter on 2 weeks as requested by Mr. Nayak, learned counsel for the petitioner in CONTC 634 of 2015, and for the respondent in CRVPET number 12. 2 weeks. Personal attendance of transfer stands.
Okay.
Item number 8.
I may be excused, my lord. I am on behalf of Mr. P.K. Naik. On last occasion, dated 15/5/2024, my lord has passed an order to file counter by the state respondent.
In fact, I've written them requested to get only 2 weeks time to file that application. It's a PIL.
By way of
2
PIL. PIL for what?
2 weeks.
PIL for what?
So they said that some encroachment is being made on the government land nearby that Hirakud Dam and other educational institutions.
My lord, that the encroachment is specifically on the embankment of the power channel that runs on that way, and some miscreants by illegal persons, those who have grabbed the land and constructed the building, and causing so much inconvenience to the local public. And on the very opposite side, there stands the BSS Medical College and Burla Engineering College. And at the very evening, every day, the alcohol atmosphere and drugs addicts are gathering on that and making the position very serious for the local public. That is the
So what do you want us to do? You stop drinking or remove encroachment or stop
removing illegal construction over the embankment of the power channel that causes hazardous to the power channel also?
No. Just 2 weeks further time is by way of last indulgence for the estate to file a counter evidence. This matter 2 weeks. Yes.
You are Mr. You are Mr. Patro? You are Mr. Patro?
No, my lord. I am Surendra Aul.
Surendra?
Aul.
Aul?
A-U-L. Aul. My lord. I'm a Bengali by caste. So somebody confused every time.
Right. That is all right. We just wanted your name because you are appearing on behalf of Mr. Naik.
Item 9.
Item 9, my lord. We have sought for some clarification, maybe taken up next week any day, my lord.
What is this about?
That is full-time faculty.
My lord, last occasion, my lord has directed the state to file counter. And my learned senior has said the counter has not come.
Your Lordship, grant us some time.
4 weeks further time is allowed for the estate to file counter affidavit. Is this case on 4 weeks? Yes.
Item number 10.
This matter is relating, your lordship, construction of village CC road by making it height, your lordship. My submission that it due to such height, there is a chances of waterlogging. Accordingly, notice was issued and counter affidavit filed. In the counter affidavit, they also admitted the maximum height of the road. This is paragraph 7 of the counter page 4.
Counter affidavit is not there on record.
When was it filed?
On 5th minute.
Oh, 5th. 5th is yes.
It was on 6th it was filed. 6th.
Yesterday.
A counter affidavit on behalf of the opposite parties is said to have been filed on 6/8/2024, which is not there on record. Most of this matter 2 weeks with the said counter affidavit on record.
11.
No one appears for weeks.
Item 12.
Some order.
Item number 13.
Item 11.
Yeah.
11, my lord. Beg excuse, my lord. Here, my lord, the petitioner had come earlier. But litigation, PIL is direct to shift the liquor subscription from the side of the school and bank, my lord. Earlier we had come. This honorable court directed the collector to make inquiry personally and directed the excise superintendent, my lord. The excise superintendent, my lord, Annexure 3, this order I have got under RT Act. He said that, my lord, page 20. Page 20, my lord.
Yes, it was directed to shift.
Shift.
Yes.
But the next para, my lord. In the meanwhile, the EPA referring to problem associated with the arrangement of an unobjectionable site in the locality has prayed for 3 months' time in his prayer petition dated 1/11/23, which is under consideration. Thereafter, my lord, his letter is 1/11/23. Thereafter, as it was not shifted, we make a repentation annexure 4. That is still pending. The superintendent excise has not taken any
Seek instructions.
Yes, ma'am. Yes.
The petitioner's grievance in the present writ application in the nature of public interest litigation is against existence of a liquor shop near Balisahi Primary School. So our attention has been drawn to list the matter. Is this case on 4 weeks? Stop. In the meanwhile, counter affidavit must be filed. Stop. Further, the superintendent of excise Ganja is directed to look into the matter and ensure that the liquor shop shifted to any unobjectionable site of the locality if not already done.
The shop is Sheragada off an OS branch. So that is what is written. That is the correct description. Sheragada off and OS branch
That
shop.
two shops.
Oh,
Two shops. One is off shop, that is Indian made foreign liquor.
So
Another is
Sheragada off shop and
both
OS
shops.
branch.
Yes, ma'am. Because
So two shops.
two shops.
And there was direction for, I think, OS shop must be there, not at a distant place. OS shop cannot be near the school because it has to be a factory there itself.
Oh, there are shop or shops?
Shops, madam. Two shops, madam.
I will file that affidavit.
It's so required. Not all, and we are not deciding.
Yes.
Yes.
And he'll file affidavit to.
Just the direction is that the off shop has been directed to be shifted as per that order, not
OS shop must be outskirts of the town because it has to be factory
Therefore,
itself.
we have mentioned.
Only, I will obtain
if the shops are required to be shifted.
Yes, exactly.
Those shops should be shifted.
Yes,
if they are not required to be shifted, you can take a plea that this is the reason why.
Yes, yes.
Item number 12.
May I please your lordship?
In the last occasion, your lordship had directed to file the counter affidavit.
Lord, sir, written, letter was written to the Lord's authorities by which.
What happened, my lord?
Yes.
After passing of the order, they are now processing to give the single bidder has been invited. There was a single bid, and that person is now his price bid has been opened, and they are going to allow him to do the work, though it is a single bid thereafter.
Earlier.
We had given 2 weeks. 1 week. 1 week for the time is wrong. Stop. Any development in the meanwhile for there was notice for tender notice also?
Tender notice for construction of high level bridge, my lord.
Development in the meanwhile in the direction of finalization of tender shall be subject to final adjudication of this case. Yes, 1 week.
1 week.
Item 13.
On the
Thirteen,
my lord. It's the nature of PIL, my lord, where I'm seeking direction to opposite party 1 to 7 to take steps to close the stone quarry which is being operated by opposite party number 8. Stone quarry, it's a because they are not adhering safety norms and they are not regulating not following the regulation, and the stone quarry is being produced stone which was excess the quantity which is permitted to him, my lord. And if you lordship see just a minute, my lord. No, my lord, if you lordship see annexure 3, my lord, which is 17 to 18, so which is that is page number 17 and 18.
Oh, show cause notice has been issued.
And there are a number of irregularities was found, my lord. Were found. First, I made a complaint on 2/1/2023. Sorry, 1/2/2020. On the basis of, and so cause notice was issued to that opposite party number 8, where a number of irregularities are found, and so opposite party number 8 being directed to reply the notice, my lord.
Wait. Annexure 4 you have given, that is a closure notice.
On the basis of that, closure notice was also given.
That is the important thing.
That closure notice was that order was there to reconsider the closure notice, but that closure notice has never been recalled, or but on still now the stone quarry is being operating, and there are number of lives is in danger, my lord, and the number of houses was also were broken, my lord.
We have seen an extra 4. What happened thereafter?
Sorry, my lord.
An extra 4 we have seen. What happened thereafter?
Just a minute.
That is the closure.
Thereafter, one reply was just a minute.
He asked,
and there is second when joint inquiry is conducted on 6/12/2023, which I was never been noticed. I mean, I was not aware. And on 6/12/2023, just for page number 21 to 25.
28. 28.
Replied that in view of the decision may be taken for revocation of closure direction and consideration of application for renewal of consent. Thereafter, the closure report has never been reconsidered or recalled. But still now the stone quarry is being operating. And if your lordship see,
How could you reject all these orders?
if your lordship see for a moment, if your lordship see page number 26 of annexure 6, ma'am.
Madam, how did you get these orders?
That I have no. That I have no instruction since it's not, I'm not directly contacting.
But it is already closed, my lord. Closure order is there.
No, it has never been closed, ma'am.
My lord.
But she's saying it's still functioning.
It is
But
still.
he's abhorring, my lord. And irrespective of that,
You are saying that it has been
no,
closed.
irrespective of that,
We will observe that.
irrespective of that, mining officer also wrote a letter to the Tahsildar, my lord, to inquire into the matter, annexure 6, my lord.
Inquire. If it is closed, no problem. You are saying it is closed.
No, my lord, it has never been closed. It's still now.
Benefit application and nature of public certification has been filed. In that direction to the party number 1 to 11 to take appropriate steps to control the being operated by opposite party number 8, which is adjacent to a village. Which village?
That is Narendra Gama Panchayat. On that is page number, paragraph 2, page number 3, my lord. Yes.
Narendra Gama Panchayat. Narendra Gama Panchayat. Village under the district of
District, my lord. Sundargarh, my lord.
Sundargarh.
Order passed by the State Pollution Control Board. Dicta dated 1/11/2000. Bracketed and 4, whereby bar 21 and 21 capital A of Air Bracketed Prevention and Control of Pollution Act 1981, section 25 and 33 capital A of the Water Bracketed Prevention and Control of Pollution Act 1974, and he bring thereunder the consent by the board carried to quarry for installation as quarry has been revoked. So, the date was directed to close down the operation of the quarry. Sovereign Council appearing on behalf of the dictator has
Revocation. That is annexure 5. Order has not been revoked. Annexure 5 is inspection report. So there in page 22, it says ask for revocation of the revoke the closure measure. Well, that development. It is there. And report is adverse.
Counsel appearing on behalf of the decision of the Commission control board. The query is going on, which is this query.
That is named as
Gayatri.
namely San Mushafo Stone Quarry.
Two.
Surface bracketed plot number 3, that near distance of the
The State Pollution Control has recommended for renewal and revocation. Why you are not pointing out? We have to look for everything ourselves. Look at page 25. Yes, prayed for revocation. They have given a recommendation for revocation.
But that
you have to point out.
That though it was been recommended, but that closure renovation, I mean renewal of the to operate the stone quarry has never been recommended, my lord. It was there in the agenda, my lord, but it was there in the, but that has been never been reconsidered.
Madam, the recommendation you yourself have given in your annexure, the deputy environmental engineer has recommended, may not have been acted upon, but this is the position.
That is not been acted upon.
Evening, my lord, period was over. That till 4/12/2023. First para.
He was separate for renewal. That is why all this problem.
And if your lordship see for a moment, page number 26, for a moment, page number, that from that is mining officer also written a letter to the Tahsil to take legal action against the opposite party number 8, my lord.
More extraction. No, ma'am. Recommended.
It was in letter on 23, 2024.
To initiate legal action, my lord, mining officer has already written letter.
So you all this you get instruction.
Mail.
Right. Outside the area support. And starting the direct the mining officer.
Who will give?
Mining officer. Of subdivision, Sundargarh.
Right. On Friday. And file an affidavit. File a counter affidavit. Disclosing the findings of finding based on his visit
Sir, yes. Yes, yes, fine. Yes, yes.
Item number 14.
May I please your lordship. Your lordship, petitioner bid was recommended by the tender authority. Petitioner bid was recommended by the tender authority after opening up the price bid, but the tender authority cancelled and invited fresh tender. It is in similar cases, your lordship has pleased to issue notice. My lord.
Can't be similar. Single tender.
No, tender was cancelled.
Huh?
Tender was cancelled for the more competitiveness.
Yes.
There is a proceeding. He has not enclosed that proceeding. The fresh tender is already invited.
Yeah, your lordship has pleased to issue notice on. Your lordship, my senior on VC, my lord.
Yes, Mr.
I'm sorry, my lord. I be permitted to, my lord, to appeal to BC, my lord. I was some. My
Yes,
lord, here is a case note that, my lord, here is a case, my lord. The tender was the tender after opening the price bid. There is a negotiation was held, your lordships. Negotiation after negotiation, it was only formal approval to the government, my lord. Yes, yes, negotiation.
No.
I am yes, the recommendation no, the recommendation was made, my lord, and the after recommendation of the tender authority accepted my price, and they come to the below estimate cost which is invited, your lordship. I come down to the rate.
Mr. Naik, are you saying that if it recommends, the government has to accept?
My lord, each submission is that.
No, it is that if it has to be accepted, then the government has to accept the recommendation, not that it is compelled to accept without then.
Your lordship is the
Right.
kind is that the tender is to be cannot be accepted by the mere recommendation, my lord. But the proceeding, the proceeding, my lord, the proceeding which is to be supposed invited, my lord, 14 works, my lord.
Mr.
They
Counsel, your client can participate in the second tender.
Milord, I beg appear tomorrow in Milord in person. Milord, physically I could not hold. I beg only adjournment for tomorrow, Milord. I will satisfy Milord. There is a division bench order of this honorable court as well as the Milord the recent judgment of Subodh Singh. If your lordship can convert tomorrow, I will appear in physical.
Tomorrow. So tomorrow, if we hear you and pass order, let us see.
As your lordship, please.
Item 15.
But here, the petitioner is a meritorious student that appeared in either aptitude test. As
Item number 15.
Yes.
So this is
That matter-
PL क्या है? PIL?
No, that is paperless.
Paperless.
Physical office have not given. Good.
Yes.
Has appeared as a OBC candidate. So Lordship kindly see Annexure 3 at page 35.
Yes.
The OBC certificate issued on 21st March 2024.
Yes.
But Annexure 4, next page, but the result was published and his rank was 763.
Yes.
And category, Lordship may mark it, category OBC, NCL, and category rank in the bottom, 763. But he was not called for the counseling. That is why the petitioner has sent mail, that is Annexure 5 at page 37. She has,
What is IICR?
that brochure, Lordship kindly see Annexure 2.
Which course?
Lord, Indian Institute of Science Education.
Which course?
That is a college. What is the course?
Court.
Course.
Course, that brochure, your Lordship, kindly see as page 13. That is admission to 5 years Bachelor of Science and Master of Science dual degree and 4-year BS degree programs. Page 30. That is the undergraduate and postgraduate course offered by Indian Institute of Science Education and Research. Just like Niger, it is IGER.
So what was the last date of application?
The last date of application was he appeared in the examination. And only because, oh, Lordship, kindly see, the certificate required to be produced. That is, your Lordship may find page, the relevant page 21. There is a reservation of seat.
21.
Page 21. The petitioner is other backward classes. The
Please
OBC.
come to your your own communication.
Yes.
Page 38.
Yes.
Last paragraph.
Yes.
Admitting that certificate is issued after.
Yes, but there is that I have challenged. Lordship, kindly see that clause that is at Annexure 2 at page 25.
You are saying as per the brochure, could have given the certificate till 2nd July 2024.
Yes, but that is the cut-off date.
No.
The Lordship, kindly see page 20.
20?
25, running page 25. So for candidates seeking admission under OBC NCL category.
Page 25.
25.
Yes.
For candidates seeking admission under OBC NCL category, as per the latest guidelines of the Government of India, OBC NCL certificate should have been issued on or after 1st April 2024.
Yes.
But that cut-off date, that is artificial date, and that have no relevance or object to be achieved.
All right.
Here, my certificate is 21st March, nearly, and I have entered appearance in the examination, and my result was published. The petitioner has ranked 763 under OBC category. But
what is done? It was stipulated. See, many candidates who did not have the certificate issued after April 1, 2024, they might not have applied.
So my status will not change, Milord, after
Your
that
status
date,
will
because
not change.
I am a OBC category through. But the certificate has been issued. It is valid for 3 years, Milord. I am the OBC
Certificate
category.
is valid for 3
But
years.
because of my certificate issued earlier, I cannot be debarred. That is similar. I cannot be.
Are you challenging this?
Milord, yes.
Are you challenging this?
That condition.
This clause?
Yes.
You are challenging?
Yes.
You have challenged?
Yes.
How can you challenge once you participated?
But that's right, Milord.
That's right then.
Milord.
No, but why has that date been given? Does it have any relevance?
Though no relevance, Milord. That date, Milord, like in other examination, there is no such date. Either NEET or Niger, there is no such date for the first time. Because this petitioner appeared in the Niger by submitting that certificate. And that Lordship knows it is settled law. The cut-off date
for everything. Cut-off date is there for everything. Come to the general EWS category.
Yes, that is also there.
Everything will become topsy-turvy.
You had applied in that category.
Yes. That Lordship kindly see Annexure 4, the result.
See?
Page 25.
25, yes.
For candidates belonging to seeking admission under general EW.
Everybody that is there.
That date.
General EWS, this
On
also.
or before 2nd July 2024. So
First
before
to second.
2nd July, 3 months time. Again for OBC. Explode the certificate on there is a reiteration.
This you were aware of. Why you have ignored? This you were aware of. Enough time they have given.
The presented application has been quite questioning the cutoff date, that is 1/4/24, whereafter questioning the petitioner was an applicant for 5-year BS-MS course under Indian Institute of Science Education and Research, IISCR. He claims to be a candidate belonging to OBC, non-creamy layer. So stop. The brochure of the IISCR for admission it was clearly mentioned in the brochure of the IISCR that only such OBC NCL certificate should be entertained, which that OBC and NCL certificates issued on or after 1/4/2024 shall be entertained if a candidate claims a reservation on that basis. Oh, stop. It is an admitted fact that the petitioner relied on his OBC NCL certificate issued on 21/3/2024. Full stop. He had participated in the process of selection and by filing the application, the petitioner has questioned the said cutoff date of 1/4/2024 as the crucial date after which has questioned the stipulation in the brochure that only such OBC NCL certificates shall be entertained, that only such that certificates issued after 1/4/2024 2024 certificates shall be entertained. 1/4.
No, 1/4, some July.
No, July was the last date, so that is automatic.
25, since we didn't upload the certificate, please give me the one. Another page 31, 37.
Next. OBC NCL certificates. After 21, after 1/4/2000, on or after 1/4/2024. As the last date of uploading the certificate was 1/7/2024.
27.
2nd July 2000.
2/7/2024. So, as the petitioner did not upload the OBC NCL certificate, he has been treated as general candidate for the purpose of admission. So, next learned counsel appearing on behalf of the argued that there is no nexus between fixation of a cutoff date for the purpose of cutoff date of OBC NCL certificate as the status of the petitioner as OBC does not the of time. So stop. He has argued that the said stipulation in the brochure is unreasonable and deserves to be struck down. Oh, there are so next, we have perused the brochure which lays down the requirements for the candidates to claim reservation against general EWS category and OBC NCA, which are based on the latest guidelines of the Government of India. First of both in case of general EWS candidates and OBC NCL category candidates, it has been specifically mentioned that the certificates should have been issued on or after April 1, 2024. Next, after having participated in the process of selection, it is not permissible for the petitioner to question the correctness of the stipulation in the brochure. Stop. Next. Even otherwise, comma, we are of the view, comma, that it will cause that it will be relative of the that if the petitioner's case is allowed to be considered in violation of the stipulations in the brochure, comma, this will amount to violation of quality clause under the Constitution, as other persons similarly situated might not have applied because of non-availability of the certificate issued after 1/4/2024. Now, in such view of the matter, we do not find any merit in the writ application, which is accordingly dismissed.
Mr. Behra, another thing you are wrong. When you say that your status is not going to change, it will change. If the family income of yours goes above 8 lakhs, then you will no longer be granted that certificate. That is why they've given that date. Because for SC, ST, they have not given any date. So that is why the date is important.
In general, EWS also.
In OBC also it because of NCL.
Lordship may unfair, but his case may be considered in view of that clause in general category.
It goes without saying that there is no reason why the respondents will not consider the petitioner's case against general seats.
In fact, they've stated that you'll be considered as unreserved.
Yes.
We have heard the opinion over 1 and 2 matter.
Yes.
Item 60.
May I please your lordship?
Why are you smiling?
By your lordship, kindly see page 14, my lord.
14.
14, my lord.
That is the reason
Tender
for you
was
to
floated.
smile.
Tender was floated by the opposite party number 2.
Yes.
And according petitioner along with others applied in tender. Then technical bid was opened. When all the bidder were on same quoting price, then lottery was invited. Your lordship kindly see page 16. This letter has issued to the petitioner to participate in the lottery process. The petitioner on lottery, petitioner became the successful bidder. Then the opposite parties did not issue any letter, any communication to the orally communicated to the petitioner to arrange the APS amount. Thereafter, petitioner arranged APS amount. Despite that, they did not proceeded in the thereafter petitioner represent to the authority concerned. In finally, your lordship kindly see page 22, my lord. On that day, such letter issued by the Superintending Engineer Khordha may permit to place you as Government Department of Water Resource Orissa Bhubaneswar decided to award the.
So the tender notice has been cancelled. So what is wrong in it?
My lord, tender, that the tender which was invited by the additional chief engineer for the above work will be cancelled.
Yes, it was awarded to a government corporation. So
This though petitioner became the successful bidder.
So what?
can you compel them?
Petitioner became the interesting fact, my lord. May I permitted to place kind notice before this honorable court, my lord. Thereafter, opposite party number 4 is your lordship kindly see page 26. Initially, tender was floated by the opposite party number 2. Improvement to Molaguni right embankment from such a place to such place. Cost was 4.43 crore. But initially,
what is clause 30 of DTCN? What is clause
30,
30?
my lord, without informing anything, without any communication, they can.
You're being asked a question, please answer. What is that clause?
No, this
Regarding-
is the clause.
may
That
I-
is clause that without informing things, anything
Can
can
be
be
done.
cancelled.
No, that
They have
thing
done
is
that.
complaining. Okay, carry on.
But your lordship kindly see, this is very interesting. Initially tender was floated up 4 crores 86 lakhs. And finally work was awarded to opposite party number 4. It is reduced down. Where that amount has gone? Your lordship kindly behind it. Your lordship kindly see page 26.
What is the reason?
Same work. Initially tender was floated such and such amount. Again, which notification, which tender float notice, I am challenging before your lordship that amount reduced.
But is that illegal?
Sorry, my lord.
The corporation has invited fresh tenders after being given that tender.
Same tender.
That work.
Same tender was published in one cost. And in what? Same work published in low cost. 4 crores 86 lakhs initially it was published. Same work, same project.
Yes.
Now that work was awarded, though petitioner has declared as a successful bidder, and accordingly, because of only communication, petitioner arranged the entire APS amount.
Only because you raise your voice, your case will not become stronger.
Petition, it has not happened in my case also. Several cases, my lord and senior standing here, my lord, it was happening. Monopolically, at any time they are inviting tender. At any time they are cancelling without any communication. It was happening.
Communication to whom?
Petitioner.
That is the
Just
notice.
communicated, just communicated. Your lordship, my lord, I may not sound in English to be cancelled, to be without cancelling, as government in Department of Water Resource Orissa Bhubaneswar decided to award the above work to Orissa Construction Corporation Limited tender, which was invited by the additional chief engineer for the above work, will be cancelled. Without communicating, without knowing nothing, they have awarded to the opposite party number 4, Orissa, and accordingly they have floated and
Participate in that.
my lord, they have already technical bid, date of technical bid opening was 30th 7 2024.
So you could have gone there.
But there is no scope, my lord. Your lordship, my lord and senior may take instruction regarding
How
the
can he
matter.
take
I can.
Instead of going there, you have come here.
May I pray your lordship may lie about the matter, my.
When was the notice, tender notice floated?
My lord.
When? What is the date of tender note?
Tender, my lord.
12/6. 12/6/2024.
First one.
No.
25-1.
25/1/2024. As per his list of dates.
25/1/2024.
First tender mail.
Anticipated.
1st March 2024. Annexure 2.
That was cancelled on 19/3/2024 mail.
First 25/1/2024.
And OCC published the second tender, my lord, on
And what is the
12/6.
meaning of paragraph 3 statement?
Sorry, my lord.
Paragraph 3, what have you stated?
Paragraph 3, my lords.
This is okay. This is very in practice.
This he has copy pasted from the PIL.
This is not done. See what is it?
Yes, writ petitioner, the petitioner is filing the present petition on his own will and not at the instance of someone else. The litigation cost, including the advocate fees and traveling expenses of the lawyer, are being borne by the
Sorry, madam.
petitioner. So in PIL, you're supposed to get the
Sorry,
declaration.
Sorry, my lord. Sorry, extremely sorry.
We can't hear you. Otherwise, you are speaking so loudly. Now we can't hear you. What did you say?
I'm hearing.
My lord is very interesting, my lord. Son has participated. Son has submitted his bid. Petitioner is the father.
No. Petition.
Okay.
No.
Kindly see, my lord.
No, my lord.
Srinivas
Sai-
Prushti, my lord.
No,
Sai Vikas Prushti.
Your Sai Vikas Prushti is the bidder, my lord. Sai Vikas Prushti participated in tender process. Your lordship kindly see
Okay, Mr. Pradhan, who is Anil Kumar Prushti?
father.
The father has got letter
My lord.
on
Because father represented scholar student. Because father represented, that's why.
Okay, so he was informed on 19/3/2024 that this is going to happen.
My lord. You can see page 16.
I'm looking at page 22.
Sai Vikas Prushti.
I'm looking at page 22. You have annexed with your writ petition.
I am annexing to 22 because father represented to the
All
authority.
right, all right.
My lord. I have mentioned in my writ application.
Tender call notice was issued on 25/1/2024 for execution of works. That is improvement of Malaguni right embankment from Patana to Ostapari. The cost of work being 486.48 lakhs. Full stop. As for in terms of the procurement tender notice, the petitioner is said to have submitted the tender papers. So there were 3 other bidders. Each of them had quoted 14.99% less than the amount put to tender. So stop. Accordingly, a lottery was drawn, and according to the petitioner, he was found successful. So stop. It is that thereafter the opposite parties took a decision to thereafter the Department of Water Resources Odisha took a decision to award the work to Odisha Construction Development Corporation. Stop. And counsel for the in the present writ application, the petitioner has put to challenge a communication dated 19/3/2024. You are challenging this. Are you challenging this?
I'm challenging tender call notice number, e-procurement notice number 6/0/2024-25 online.
Later, accordingly, Odisha Construction Corporation Limited, bracketed opposite party number
4.
Opposite party number 4 has issued an NIT on
15/7.
12/6, ma'am.
Under 6 annex.
Page 30.
15/7/2020.
12/6, ma'am. 12/6, page 30.
12/6/2024.
Prayer is wrong.
thinking there's submission of the application from 15/7.
In the aforesaid background, the petitioner has challenged the said tender call notice dated 12/6/2024, bracketed wrongly mentioned as 15/7/2024 in the rear portion of the petition, bracket closed. Stop. Next. Learned counsel appearing on behalf of the petitioner has argued that it is highly unreasonable. It was highly unreasonable for the state opposite parties to have taken a decision to award the work to Orissa Construction Corporation Limited after the petitioner was found successful in the bidding process. First off, he has submitted that instead of the work to the petitioner, the work was wrongly given. It was wrongly decided to get the work executed through the corporation. First off, he has also submitted that whereas the amount of the estimated amount for execution of work was earlier 4 lakh.
4 crores 86 lakhs.
4 crore 86 lakh, in the subsequent tender notice issued by the corporation, the amount has been reduced to
4 crores 43 lakhs.
443 lakh.
4 crore 43 lakhs.
That is illegal.
No, how it is illegal? It was reduced.
No justification. Stop. Next. We are not inclined to interfere in the present matter as the petitioner cannot claim by way of right to be awarded the contract. So stop. It is the discretion of the state government to take a decision as to whether the work, as to whether it shall continue with the tender process or recall it, in the interest of, in public interest. So stop. Be that as it may, in the present case, state government of Odisha decided to award the work to a public sector undertaking. So Odisha state, what is that?
Odisha Construction Corporation Limited, OCC.
Construction, a government of Odisha undertaking. So stop. We do not find any unreasonableness in the said decision. So stop. Do not find any merit in the submission advanced on behalf of the petitioner that the action of the opposite parties is arbitrary because the amount of work was subsequently reduced in the second tender process initiated this time by Odisha Construction Corporation Limited. Now stop. We cost. Right. So we do not find any merit in the presented application, which is accordingly dismissed. Yes.
Item 17.
The nursing matter is supposed to be listed yesterday, would not be listed. I think Monday all those matters have been posted. Let him take instruction on this matter.
My lord, in these cases, they are relief for the grant of NOC for the session 23-24.
No, I have also filed an application
Let us see the
24-25. I'm not concerned about 23-24. I'm not concerned about 23-24.
24-25, what is your case?
Right.
Renewal. No.
There actually, if your lordship looks at the,
Come to the prayer portion.
prayer is 23-24. I have filed an interim application, in fact. So that was actually long back, it was there. If your lordship looks one ground,
A different cause of action altogether. You can file a separate application. Not by interlocutory
This is
application.
infructuous. You have filed this on 29/7.
I'll file it, Lord. I'll file
Back
it.
to this.
I'll make an application to
You
amend.
file first application, we will consider your case falls in either of
No, the reason for filing this one is, one very simple reason is that, if you also kindly turn to page 21. Page 21, the ground of rejection that I cannot even apply for fresh one. That has to go. Court cases, I got that, page 21, serial number
Annexure.
64.
Annexure.
So Annexure 3.
Yes.
Annexure 3 at page 16. I am at page 21.
Yeah.
Serial number
College.
64.
Amit College.
Sir, Pathani Samanta College.
21. Page 21, item
64.
64. Yes.
Right side,
Yes.
ground of not considered. Court cases of Pathani Samanta, the matter under sub judice, WPC number 16559 of 2023, which is not correct. Page 24, let's you kindly see. Page 24. Is a different college altogether. Is Pathani Samanta Nursing Center, GNM, and another. And that case has already been on page 26.
That list is of the year 23-24.
No, but I cannot apply even for 23-24.
Page 16 may be.
The reason that
list of institution not considered for
You
this.
cannot apply because you did not apply.
Sir, two reasons are there. The reason for which they have rejected that this comes within that college, which is not correct.
When was this rejected?
Rejected in September, Madam.
Rejected
2023.
2023.
Correct.
When did you file?
I filed recently, but I'm not claiming 23-24 or 24-25.
How can you claim even for 24-25?
No, I'm not asking for that. I'll file a fresh one. But here the reason they have mentioned, which is not absolute.
You are right. You may be right, but what can be done?
So this has to be struck down.
You are coming after so many.
Sir, I'm not seeking for 23-24 even.
We understand, Mr. Mishra. This writ petition is confined to 2023-24. Stated anything about 24-25.
Right.
And then your application was rejected in September 2023.
Right.
You came in July 2024. And in the meanwhile, they had come out with notification for you to apply for subsequent session to 2024.
Only prayer is, this should not stand as a bar for me to apply.
No, because there is bar. Because the date have crossed. The date has
No, date bar I'm not saying. The reason they have mentioned. The reason they have mentioned is absolutely obliterated. It doesn't survive.
Well, what happened?
Number one, that REIT application do not relate to my case, my institution.
There is dispute pending before the.
Mr. Mishra, you could have, the matter would have been different had you come in October or November or December. Now we are in July. You filed the writ petition in July. So you blame yourself, not the yes, they may be incorrect.
Only point I say, I'm not concerned about 23-24 or 24-25.
All right.
The reason they have mentioned here is not applicable to me.
All right. We can observe that. That can be observed, Mr.
My lord,
Let them justify the reason.
what happened, my lord, in this case, we find that there is a dispute in between their management regarding
There
cost.
may be dispute, Mr. Counsel. We will just observe that the reason which you have assigned because of pendency of this does not come in way of the petitioner's application for subsequent.
Correct, madam.
There is an order passed by this honorable court that unless and until that dispute is resolved.
Pendency, that is the order. So you will reject on the basis of the order, not because of pendency.
Yes, yes, madam. Yes.
Pendency, and see, if he applies, then you will not refer to this because this was only for 23-24.
Right.
The present writ application has been filed seeking the decision selling raising grievance against non-consideration of the petitioner hyphen institution for grant of NOC for BSc nursing course for the academic session 2023-24. The petitioner's case was not considered by the DMET on the basis, on the ground of pendency of
WPC number 16559.
on the ground that some matter was under sub judice by WPC number 16559 of 2020.
Right.
So from next learned senior counsel appearing on behalf of the petitioner has stated that the said WPC number 16559 of 2023 has been disposed of.
Disposed of.
Has been disposed of.
And no way connects the petitioner. No way concerned about it. Right.
First off, he submits, having realized the position that no objection certificate can be granted for the academic session 2023-20, he submits that if any application is made by the petitioner for future grant of NOC future, the same may not be rejected by the DMET on the ground of pendency of WPC number so and so.
Right.
We'll stop. Next. Fair stand taken on behalf of the petitioner. This application is disposed of with an observation that since it is an admitted fact that the said writ petition has been disposed of, if any application is made for grant of NOC by the petitioner before DMET in accordance with the procedure prescribed, the same shall not be the DMET shall decline to consider the case only on the ground of on the ground of pendency of WPC numbers.
Right.
Item number 18.
The short grievance of the petitioner here, though the petitioner is the successful bidder, successful tenderer, worked for 1 year, 3 months, but subsequent work orders are not being issued in their favor. That is short grievance before my lord's lord. Tender notice for hiring a payloader. He became the lowest bidder. Letter of acceptance was issued. Then work order, the total period for which I am successful is 3 years, admittedly 3 years. Now my 3-year period, I have worked on the basis of different spells of work order. Initial work order for 1 year. Then they appreciated my work. They gave recommended certificate that my work is satisfactory. The review committee also suggested that my work is satisfactory. They extended for 2 months. They issued further work order for 2 months. Thereafter, 1 more month. Then they are not issuing. Therefore, I am before my lord's note. But admittedly, fact remains that my letter of acceptance has been challenged before this honorable court. The writ petition is pending. The stay order is passed. My employer has filed an application over there. Allow me to issue work orders in my favor.
What is that case?
Lord, that I have given the number. Page 9, that is WPC 18516 of 2023. That the page 98, my lordship will kindly see. In this brief, page 98. My employer has filed an application to issue me the work order. But my limited grievance now is either your lordship may, whatever may consider it, whether your lordship will permit me to approach them in this regard and let them pass an order so that
liberty we can give you. But representation we will not do.
No representation, Lord, I will not ask for. It will go. Let it be decided, my lord. Let it be decided.
This matter on 4 weeks along with the WPC number.
I'll give it. 18516. 18516 of 2023.
18516 of 2023. So in the meanwhile, the who accepts notice?
Lord MCL, Lord, should I serve my survey copy?
Yeah.
MCL, yes.
Issue notice.
Lord, instead to avoid further delay, if I can be permitted to serve a copy on the council appearing in the connected matter, that will expedite the matter.
No. But what about MCL?
MCL only. MCL is also a party there. My
come tomorrow.
Yes.
Tomorrow.
That will be fine. Yes.
Please inform him.
I'll inform.
Serve a copy.
Not I'll serve it. Grateful.
19.
May it please your lordships. My lords, we are challenging Annexure 1, which is a fresh tender call notice for, my lords, orthopedic implants. That is at running page 12. Tender call notice for supply of orthopedic implants. Lordship, yes. Annexure 1. My lords, my grievance is that under Annexure 2, my lords, a tender call notice was floated, wherein, my lords, there was a tender call to supply items. Annexure 2 at running page 20, tender call notice for empanelment of medicine stores regarding supply of drugs, consumables, and other items to Bhima Bhoi Medical College Hospital, Balangir. This was floated, my lords, and this other items and consumables have never been defined anywhere. Now, my lords, under the general terms and conditions at running page 22, the medicine store has to supply all medicine, consumables, and other items.
This was issued the tender call notice.
Which one?
You're referring to?
This is at Annexure 2 at running page 20.
Running page 20.
Yes, sir.
Just. Yes.
This is tender call notice dated 5/1/24.
Yes.
If your lordship sees the heading of the notice, tender call notice for empanelment of medicine stores regarding supply of drugs, consumables, and other items, College of Balangir, my lords. Now, at running page 22 are the general terms and conditions. 1. The medicine store has to supply all medicines, medical consumables, and other items at the rate of contract price as per agreement. Now, other items and consumables also include orthopedic implants and other, my lords, accessories relating to orthopedic implants, which is evidenced by the fact, if your lordship sees, Annexure 5 series at running page 32. Lordship gets it?
Yes.
Running, if your lordship sees the heading implants, Bhimabhoi Medical College and Hospital, Balangir, my lords, humerus, interlocking, nailing, one. My lords, it goes on.
But this is prescription.
No, my lords, these are the orders placed on us for the consumables, which relate to orthopedic implants. The prescription, these are the orders.
There was tender notice for fixing rate contract.
Yes, sir.
All right.
Yes.
What was the rate fixed?
Rate fixed is as per the contract. We have no
Where is that?
grievance. My lords, we have no grievance with that.
Where is that? If you are seat, you are challenging Annexure 1.
Yes, my lords.
This is tender call notice for supply of orthopedic implants.
Implant.
According to you, this is consumable, and therefore it is covered by your rate contract.
By the previous
so what
contract.
was the rate fixed? Suppose the employer has to purchase pins.
Mal.
All right.
Mal.
And there is annual rate contract for annual rate contract for pin, or pen.
Mal.
Or pencil.
Mal.
So annual rate is fixed. So where is the rate fixed for this?
My lords, at running page 29, that is the MOU signed between us. The second party has to supply all medicines, medical consumables, and other items to DH, BB, and CH, Balangir, at the rate of 7%.
Please tell us what is the rate. Come to Annexure 1.
Mal.
And tell us they have to orthopedic implants.
Yes, ma'am.
What is the rate of orthopedic implant?
My case is, my lords, my case is that the tender that was issued for medicines and other items and consumables include orthopedic implants.
Where is that? We are asking where is
Where is
My lord,
it?
that is evidenced by the, my lord, if your lordship.
The moment, please.
I get your
Moment
lordship's
you
point.
say rate contract, you will have to demonstrate that this was the rate fixed.
My lord,
Where is the rate fixed?
rate fixed is as per the agreement, which is 7% purchase price of that item. I understand what your lordship is getting at. I will, your lordship keeps it to next week. I'll get that rate. Rate chart we will get, my lords.
It's impermissible. It's very deep.
Because during subsistence of our agreement, they have floated another tender.
Impermissible. This is impermissible unless
Mal.
the specific rates have been fixed for specific items.
Mal.
There cannot be a rate contract.
My lords, I'll get that copy, my lord. I'll give a copy of that.
Requested on behalf of the petitioner, this matter on 2 weeks.
Item number 20.
2 weeks, my lord. Okay.
May it please your lordships. Well, this is a matter concerning a sand quarry tender, a tender for auction of a sand quarry, where, my lords, the tender is at page 17, but I'm really challenging, my lords, the communication dated 25th of July 2024, which is page 96.
Which is, which page?
96, my lords.
Annexure?
It's Annexure 8.
Yes.
Your lordships will see that it says simply that for the mine, etc., you have been evaluated as rejected. It's a single word, my lords, rejected without any reasons whatsoever. We are aggrieved, my lords, because according to us, we are fully compliant in the technical bid. And we are being barred from participating. That is, our financial bid won't be open and we won't be able to participate in the auction. So our respectful submission, my lords, is I'm aware that your lordships have taken a view in previous matters that reasons need not be given in a rejection. But respectful submission is that this is a category of natural resources where the Constitution bench, your lordships may recall in the presidential reference, has held that it is important that the state recovers the correct price for these natural resources and it should not be at a discount. Now, if I am barred, the effect is that the state will not get what it ought to be getting. All that we are asking at this stage, my lords, is that one more thing, which very important thing I need to show, my lords. If your lordship comes to page 30, please see, my lords, the
33 which annexure?
33 is
Annexure
the
1.
schedule. Yes, which is part of Annexure 1. It's the schedule. Your lordships will see that serial number 13.
Yes.
First of all, at between serial number 11 is announcement of technically qualified bidders. If your lordship looks at that document, the impugned communication, your lordships will see it's issued 25th of July. Now, after that, they open the financial bids, and at 13, the selected bidder is to be announced on 26th of July to 5th of August. They haven't opened it yet. They haven't opened any of the bids as of today. As of today.
Yes.
And all that we are asking is that the reasons be given to us, and in the meantime, that they should not proceed with the auction and the opening of the bids.
Yes, why do you reject like this?
Yes, I will obtain instruction because the ground terminals, of course, no reason has been sent, but they have only stated that rejected mirrors. I'll take instruction on which ground? Right, mirrors. Yeah, right, mirrors. I understand, mirrors.
In the meantime, my lords, if they would not proceed, finally, until they come back and tell my lords, and they can even come back and tell my lords what it is, as quickly as possible. We're not interested in holding up anything, my lords.
How much time will you take?
I will obtain instruction within a week. The reason for mirrors rejection, I can get it mirrors within a week. Mirrors. Only the reason why it has been mirrors rejected and the entire bid process mirrors. I can get it.
Okay. Mr. Venugopal, what we intend to do is that we shall not, but we shall indicate in our order that whatever is done later shall be subject to final adjudication, and then this should be communicated to someone to whom the finally this
date of communication is 12th of August. Mirrors.
To the successful bidder.
Yes.
This shall be communicated that whatever is being done is subject to final adjudication of the case. In case it is finalized, then that will be subject to final order of this case.
Well, I was only making one submission. There can't be any harm, my lords, if we are allowed to participate in the auction so that they can discover the best possible price.
No, not let the affidavit come.
Very well. Then would your lordships request them to put it in quickly, my lords, so that if your lordships indicate a date.
2 weeks.
My lords, by that time, the whole thing may be over, my lords. My friend said 1 week.
Next week.
No, next week I can get the reasons, lords. If you also want to file an affidavit, only reasons I can put mirrors within a week. I can get the seats, not the ground of rejection that I can put before also within a week.
No, but we should decide the matter finally. Why should we wait?
Then we have some time to file the counter affidavit.
2 weeks.
Two weeks plus I can file that affidavit.
We
Yes.
will take up your matter after 2 weeks. We know how to protect your interests
Yes,
also, Mr. Venugopal.
Most grateful, Malad.
And senior counsel appearing on behalf of the petitioner has drawn our attention to Annexure 8 to the writ application, whereby the petitioner's bid, after evaluation has been rejected for the mine bracketed Tahsil Gardapur, block name Chitropala Sand, Sairat, Talaksuma. That is the description?
Yes. Yes, Malad. Yes.
Stop. He has submitted that except for the word quote unquote rejected, the said communication does not indicate as to why the petitioner's bid was rejected. Technical bid, that was what?
Technical bid. Your lordships are right.
Technical bid was rejected. Stop. He has submitted that. Which annexure is that? Next.
Your lordships are talking about the time schedule, Malad?
Yes.
That's Annexure 1 at page 33. It starts at page 17, but it's at page 33 that the schedule is given.
He has further submitted. He has also drawn our attention to the time schedule for the said minor mineral block, and has submitted that the respondents are proceeding to announce selection of bidder, which according to the said time schedule was to be done between 26/7/2024 to 5/8/2024. Stop. Till date, however, the name of the selected bidder has not been announced. Stop. He submitted that in such view of the matter, either the respondents be restrained from further proceeding in finalization of the process of tender, or the petitioner may also be allowed to participate in the tender process. Stop. Next, in the given facts and circumstances of the case, we consider to direct the state opposite parties to file a counter affidavit within 2 weeks. Stop. List this matter on 2 weeks. Stop. We make it clear that any action taken in the direction of finalization of tender shall be subject to final adjudication of this case. Stop. If the respondents decide to finalize the tender process, the successful bidder will be clearly informed that the same is subject to final decision in the present case.
It's one thing may I point out.
Malad, may I?
I'm appearing for 1 and 2.
Just a minute. Yes.
I'm appearing for 1 and 2. Yes, yes. Kindly.
One request, Malad.
Yes.
If your lordships are going to hear it finally, if they would file their reply within 2 weeks, and we can be given 3 days to file our rejoinder, your lordships could take it up immediately after that, Malad.
3 weeks, then we will take up after.
Very well, Malad. 3 weeks then.
3 weeks within first 5 years.
I point out.
And
opinion
your
was-
lordships may give us the right to file a rejoinder, my lords.
Therefore, in the petitioner shall be at liberty to file a rejoinder to the counter affidavit in the meanwhile.
Most
3
grateful,
weeks
my
for
lords.
filing counter affidavit. Matter will be listed after 3 weeks. You will
Yes,
have the opportunity to file your rejoinder if required.
most grateful, my lords. Most grateful.
The OP number 3 seems to be a private party. The notice or not allotment is because OP number 3, one MSTC Limited representative director having its results such
We will
and
consider that day
no.
whether
That's only the auction platform, my lords.
I don't know, my lord. They made him a party.
Number 3, respondent number 3 is the auction platform.
I see.
And the communication was through them, my
And
lords.
I can appear for 1 and 2 only. 3 notice may not be issued at this stage. Plus also consult letter.
1 and 2. Within first 5 cases on after 3 weeks.
Much obliged, my lords. Most grateful.
Yes.
Item number
Most
21.
grateful.
Yes.
My lord, can see order dated 15.
Item number 21. I've got the recent development letter dated 3rd of August. His position has been brought to at serial number 5. He was there at serial 600 something percentile direction. He has been brought to serial number 5, and the clearance from the finance department, also administrative department has been obtained. Now the matter is Chief Minister, because he holds the office of water resources. Thereafter his appointment order shall be issued. That is the instruction given to me on 3rd of August.
So by what time?
Since 3rd of August means it has been sent 1 week before me. So hardly it will take a week's time. So 10 days after loss may put it, by that time it will be done.
As requested on behalf of the
My friend can also take a copy of
contenders,
this.
contenders list this matter on 3 weeks.
My lordship, Blackstock is directed the State Council to file affidavit with regard to.
Affidavit means I filed today only through e-filing. I've got the copy. I may serve my friend. Because here we have taken a stand that eviction process is going on. So far as not 2 temples and 1 school which has been abandoned, that those will be demolished. And so far as Gram Panchayat building and another building of government.
Another day, minute.
Yes, no, I'm not saying that should be destroyed. That is our stand.
Copy of the counter affidavit has been served upon learned counsel for the so-called reply or counter affidavit.
So-called reply, sorry.
So-called reply has been served upon learned counsel for the petitioner today itself. So let the same be filed in the registry. Have you filed?
I've already filed. I'm giving the hard copies to my.
Do it in the registry.
Yes, yes.
Said so-called reply has been filed. You can see online. So list this as requested on behalf of the petitioner. List this matter on 2 weeks.
Item number 23.
Yeah.
Non-compliance of the order, your lordship, I will take your lordship to the ordering portion at page 16 of the brief. Considering raised by the learned counsel for the parties and after going through the records, this court is of the opinion that the order dated 9/4/2024 under Annexure 7 passed by the opposite party number 3, Engineer-in-Chief, Rural Water Supply and Sanitation is liable to be quashed and is hereby quashed. Accordingly, the matter is remitted to the very same authority to adjudicate the same afresh and pass appropriate order, taking into consideration clause 21.1 of the notice inviting bid and under clause 36 of appendix 9 of the OPWD code volume 2. The fact here is like this, man.
So whether this has been done or not?
That has not been done. They have passed the order. I have annexed. They have passed the order on 7/6/2024, Annexure 2, but that is not taking into consideration clause 21.1.
That you will have to challenge. That you can challenge, not contempt.
Well, they are directed to do as per.
That you can challenge. The petitioner has alleged disobedience of this court's order dated 17/5/2024, passed in WPC number 12641 of 2024, operative portion of which reads as under paragraph 6. And counsel appearing on behalf of the petitioner has argued that though the authority has passed an order afresh, but the same has not been done in accordance with the order dated 17/5/2024 of this court. And therefore, case of disobedience of this court is made out. Court's order is made out. So next, since
all are same, all 4 items same.
Since an order has already been passed by the that is the engineer in chief, rural water supply and sanitation, we are of the view that no case of willful disobedience of this court's order is made out. So correctness of the decision taken by engineer in chief can be gone into in an appropriate proceeding, but not in present contempt proceeding. So the contempt proceeding is accordingly. Next, the petitioner shall, however, be at liberty to question the correctness of the decision taken by the engineer in chief before appropriate forum in accordance with law.
All the connected cases same.
Item 24.
The petitioner here was blacklisted on account of certain tender work. The blacklisting period was 5 years. That's the part of the writ petition out of which this content arises. Challenge that blacklisting order before this honorable court. This honorable court, on the ground of non-compliance of natural justice, was pleased to set aside the blacklisting order with a further direction to reconsider it following due process of law. I communicated that order. They gave me a show cause notice. I filed a show cause. But thereafter, the matter is in limbo. They are not taking a decision in the matter, despite specific direction to consider it. My whole process is stalled. For 5 years, they are not allowing me to do any work. My digital certificate.
But why are you worried?
Beg pardon.
Why are you worried? See, your order of blacklisting was set aside.
Yes.
There is no order of blacklisting.
Absolutely correct, my lord.
Now you file your reply. And you want them to pass an order.
Lord, in fact, the problem is they have blocked my DSC, digital signature certificate, on account of which I'm not able to participate in any tender work.
Why that has been
because
blocked?
the digital signature certificate, unless it is opened, I can't sign.
Why have they
because of this blacklisting?
Blacklisting order has been set aside.
That they should. That's what they are not understanding. That's what they are not understanding. Either your lordship may direct them to Lord.
In fact, there is no time limit, but you are also only directed to reconsider it, and dispose of the writ application. Accordingly, now the IIT Bhubaneswar, the engineer, they have been directed to inquire into because there was a bridge collapse, for which you are declared blacklisted. That inquiry is going on by the IT. They will be submitting a report very soon. After submission report by the IIT Bhubaneswar, we will take a decision. That is the instruction.
Meantime.
3 weeks time, you will also grant.
No, in the meantime.
No, that digital signature. No, we will take a decision. It will depend upon that. No, there is no direction as such.
But there is a direction. Lordship may kindly see, there is a direction.
It is a petition.
No, it's a contempt application.
Contempt, no contempt is met.
You kindly see, Lord, page 13. There is a specific direction to reconsider it, which they are not doing.
Page
Question of
1,
time
please.
limit, let them do that. Let them do that. If they are asking for a time limit, my lords can do that here also.
No, we cannot do. We cannot modify the order.
My lord, writ is there before my lords. Your lordship is if you file an application in the disposed of matter, that can be done. It's a question of technicality only. Yes. Lord, learned friend says.
Contempt matter, this contempt was disposed of.
No, contempt is pending.
Page 13 is the order, Lordship may kindly look at.
Contempt is pending. Page 13 is the order.
Paragraph 5. Phrase contempt. It has been listed first time.
For the first time it has come. Let them, they should decide or give me my digital signature. That's all. No, your lordship may not decide the second part, but first part they should do it. They cannot keep me in a limbo for indefinite period.
They can do it tomorrow.
Right.
That will be more harm.
Yes. Lord, as discussed, Lord, let them do it. Instead. No, time limit was not fixed. Time limit was not fixed. But it is expected because merely. Lord, there is a judgment. There is a judgment of this court, 90 days. Of course.
1 year.
90 days, Lord. This court says 90 days.
Lordship, item 66 I had mentioned it. Item 66, Lordship. Look in the urgency matter I had mentioned.
Should have mentioned at 4.
So I am sorry, Lordship, I'm voting here, but Lordship.
Mention tomorrow.
Rest, my lord. Rest of the
Two more. Grateful, Lordship.
Monday.
Monday, top 5 cases, Lordship, item 66.
Monday.
Lordship.
Monday.
Lordship. Grateful, Lordship.
Lord.